Withdrawn.
Deep breath.
Diary may be called for loss.
All right.
35 to Chakavati loss from Bahira side.
11, 12.
Bless.
This case when a charge sheet is laid. I have been in custody 19/7.
And copy of teacher.
125 days. Investigation is complete.
Okay, we have to call for scan copy.
Not FIR named it. The suspense.
But
Answer.
charge sheet has been submitted against you without knowing anything. How can you just say dacoity? Scan copy of TCR.
Little earlier. I was saying my co-accused
All right, same.
in the public.
FIR is the Your Lordship.
Any earlier case was filed?
Yes, Lordship, the accused, the of accused pending, Lordship.
Who is this for?
Lordship, in this case, the accused petitioner one is the third number wife of the accused person, Lordship, and accused the custody, Lordship, 7/10/2025, Lordship, and the other petitioners are the son of the accused. And Lordship, the informant got married to the accused person in the year 2012, Lordship, with the consent of mutual consent, Lordship.
So accused has already approached this court.
Yes, Lordship.
And now?
Case is pending, Lordship.
I'm not following you.
Lordship, that is different case, Lordship.
Huh?
That is different case, Lordship. Out of same affair, that is different.
No, FIR is same.
Yes, Lordship.
8/9/25.
Yes, Lordship.
And the informant is Binasri Bosumotari. Accused is Sohim Ali and Kiran Bosumotari.
Yes. In this case, Lordship, the petitioner is Kiran Bosumotari,
Hmm.
third number wife, Khairul Hussain, and Imran Hussain, son. Son of accused
So
person.
Sohim Ali has already approached this court.
Yes, Lordship.
Oh, there are 3 accused.
Yes. Total 4 number of.
When is the case fixed then?
Is a regular bill?
Yes, that is regular bill. That is regular bill.
Regular bail. So we must have called for the CD
Yes, on the same date.
on the same date. I don't know.
Lordship, I have to check.
After some time.
All right. Maybe you can check from the PS case number.
Lordship.
When you have called for this, we have called.
Yes, Bongaigaon PS 24120.
Yes. No, that date.
Date is good. After some.
Very please, your lord. There is bail application, my lord. And petition that before I proceed, I want to appeal on report. Number 9, my lord.
Hmm.
He has already been arrested yesterday. He may be a staff. Who's number 9? A petition number 9.
All right. And then,
First of all, arrested, my lord, not yet arrested, my lord. Total, my lord, accused here, 13. Earlier, 2 arrested. Yesterday, 1 is arrested. Now, except accused number, my lord, 9. 9 before your lawsuit. They belong to same family member. Your lawsuit find FIR page 13, my lord, over a trifling matter of releasing of air from the wheels of the informant. Page 13, my lord. It is a translated copy. Were lost by the my lord, the younger brother, the victim, alleged victim, saying that my lord, on 21/9/2025 at 9 p.m. at night, he received an information that somebody released air from wheel of his vehicle parked at Amungaon Sariali Mart. Having received the information, aware of the informant, rushed to the spot, then accused, while staying there in a premeditated way, assaulted him with some lethal weapon, resulting in sustained injury. Both the cases may be under section 1182, 109, but at best, my lord, this case would come under section 122, 2 of the BNSS, that a voluntary causing her, if it is allegation made there, assuming to be true.
don't know, we don't have the medical report before us.
Along with the injury.
Also, for the my lord, I want to submit this, accused number, number 10, my lord. He's a student, he is presently pursuing, my lord, IS coaching course in Azmul IS Academy. One thing my lord, annex, page 20, my lord. He also submitted the application to the officer in charge of the particular police station, with my
So
lord,
he,
with my lord CCTV footage.
his police verification is over before IS.
And he says, my lord, on CCTV footage also sent, my lord, on that particular night, he was in, my lord, Azmul IS Academy, my lord. That Yellow 1 year, that is also endorsed by the project director of Azmul IS Academy, my lord. The petition number 10, my lord.
All right, it was earlier rejected. We'll call for the CD.
Rejected, my lord, line code.
Yes, after perusing the CD. Given it.
1512.
Please.
10, 1012.
10,
10.
Right.
Applicable. You know, paying for causing of criminal proceeding lordship. That is the basic allegation that you not supply the material after receiving one amount. That is for the same cause of action, the same informant, same found loss. 2 FIR is lost. One is loss in Damaji PS, that is I have
Updated TCR has come.
Yeah, I see. And another FIR, same lordship, loss in the Amrop Metro, is previous. And one NIC is also pending. And both the FIR PS case lordship started submit and after start also framed. And now now trial is going on, evidence is NI is also going on. Now kindly see the page 21 is the FIR page 21. Civil sir. It's believable that the petitioner not supply he payment one after another, one and after another without supply any material. He claimed that no any material submit and he payment one after 1 month, thereafter half a month, another 2 months. Is it was believable? Petitioner already supply lordship and out of 9 lakh something he supply have the kindly is second FIR kindly see the page 40. Second FIR page 41. Same cause of same information, same.
Yes.
Page 41 is the second FIR. Same information, same amount, that is only amount mentioned, Lordship. No details given when he came. Same allegation. That is laws before the Bhagavatam under this for PS. And earlier one is the damage. On damage PS, they are not get anything. Thereafter, he subsequently, on damage PS, he got bail. Thereafter, he lost another affair in the yes. Same allegation. I currently see page 55 Lordship. Sale invoice Lordship, he is already supplied material. Page 55. Inform is BPL Gogol Lordship. Customer details if see the left side and BPL Gogol Lordship and GST number also here Lordship. And right side is the invoice number Lordship. TPL double 134/2124 and page 56 Lordship. Yeah, page 55 Lordship, he supply materials like 7,395 rupees.
Yeah, we are not going into all that now. Yes, respondent.
Lordship, yeah, if you see the page 58 Lordship, there is a Daniel Lordship. He is received and says supply Lordship, he is 55, 58. And out of the same invoice Lordship, he informing also claim GST loss. That is page 59 loss. Again, the sale, the sale invoice Lordship. 50. For the same allegation Lordship, he lost one NICAS Lordship. That is page Lordship, page 60 Lordship. An allegation, if you see that page 62 Lordship, the same allegation. This para 4. That he received 10 lakh rupees. If he is not supplied the 13 lakh, then he why is received 10 lakh check. That means the petition already is supply material. Therefore, the ingredient under section 420 loss not attack Lordship, because if it constitute offense under section 420 Lordship, there must be dishonor from the very beginning Lordship. There is no any very beginning intention Lordship to see the because if already supply the material, some amount maybe he is not supplied because during the COVID-19 period Lordship, due to the shortage of labor and price, he could not complete the entire work. Therefore, the criminal intention, there is no any criminal intention. I have honorable Supreme Court judgment also. Permit me, I yes.
Yes, yes.
Paras 5, 6, and 7 Lordship. Kindly see the page 5, page 3 Lordship, para 5. This court in number of judgment has pointed out that the clear distinction between civil wrong in the form of breach of contract, non-payment of money, disregard to and violation of contractual term, and criminal offense under section 420 and 406 of IPC. Repeated judgment of this honorable, however, are somehow overlooked and are not being applied and enforced. Will be referring to this judgment that the impugned judgment is the application filed by the appellant under section 482 of survey on the ground of delay and less, and also factum that the charge sheet has been filed on 12/12/19. This ground and reason is not valid. Now come to paragraph 7 of the here in the Supreme Court in Lolita Chakraborty clearly said that there is a clear difference in civil dispute in the form of contract lordship. There is contract lordship and disregard non-payment of money and violation of contractual term. So there is a contract lordship. Yes, sir. There is a money. Currently, it's a pair of 7. Similarly stated by this court in YB Jose and another state of Gujarat and another 2019 state that the contractual dispute or breach of contract party should not lead to an initiative of criminal proceeding. The ingredient of sitting as defined under section 415 of the IPC is existence of the fraudulent or dishonest intention of making initial promise or representation thereof from the very beginning of the formation of contract. Further, in the absence of averment made in the complaint petition, from the ingredient of offence can be found out. The High Court should not hesitate to exercise its jurisdiction under section 482 of CRPC. Section 482 of the CRPC have the inherent power of the High Court, as it serves as a salutary purpose which a person should not undergo harassment or litigation for a number of years. When no criminal offence is made out, it is one thing to say that a case has been made out of for trial and criminal proceeding should not be caused, but another thing say that the number a person must undergo criminal trial despite the fact that no offence has been made out in the complaint. That is same. This case is also similar situated case. And if you see the page para 9, Lordship, we will assume that the assertion made in the complaint are correct, but even in a criminal offence under section 420 read to section 415 of the IP not established in the absence of deception by making false or misleading representation, dishonest concealment or any other act or the omission or inducement of the complaint to deliver any report at the time of contracts being entered. The ingredients of LS offence are neither set nor can be inferred from the averment. The prayer is made to the police for recovery of money from the appellant. The police is to investigate the LS offence allegation which disclosed criminal act. Police does not have the power and authority to recover money or act as civil court for
Yes, yes, we have finished. All right, we have gone through that.
Lordship.
Yes, respondent.
Lordship, there are two FIRs, Lordship. Both the FIRs are charged, Lordship. Both case proceeding has
This
been-
petition is in respect of both.
Lordship? Yes.
Huh?
Lordship? Both.
This present revision criminal petition is in respect of only one FIR or both?
Both. Only one FIR.
Lordship, but the second FIR also has been
This one first.
state, Lordship. State, Lordship. Second FIR also state, Lordship.
Both FIR are state.
Both FIR is.
Yes, Lordship.
And trial, NICAS style is going.
Huh?
NICAS style is going on.
That is a different matter.
That is different. Allegation is same, Lordship.
Lordship, but Lordship, one thing I have to say, Lordship. Lordship, he is an habitual offender, Lordship. Lordship, in the year 2021, this case is of year 21, Lordship. Lordship. In the year 2021, he has done one more, Lordship, like the same offense, Lordship.
Yes, he may be a habitual offender, but still that doesn't make him a criminal offender. He is a civil offender.
Civil.
The same.
One more thing, if you see the bank statement which is collected during the charge Lordship, enter payment is made in the account of the Dihang Engineer Private Limited Company, not a single amount in the private one. But in FIR, the company is not as a party. But also, apart from that, the police also not added a charge in the FIR against the company, Lordship. When police collect the bank, or police ought to have to as a accused in the company. But police not a charge in the accused as a company as a accused. Only accused.
Lordship, can I show the order, Lordship? Can I show the order, Lordship?
Which order?
Also, another case, Lordship. The same offense, Lordship, he should take money, Lordship, that he will supply materials, but he don't.
This is a
We are
contradiction.
concerned with
There-
this.
there-
In revision, we
there is-
cannot take those things into consideration. Whether he is a habitual offender, that is to be proved in an appropriate proceeding, not here. Heard Mr. So-and-so learned counsel for the petition. So heard. And counsel for the respondent number
Lordship.
2. Respondent number 1 is represented by learned additional public prosecutor. The present application under section 528 BNS has been filed seeking quashing of charge sheet number cost. The proceedings before the learned court below has arisen out of an FIR lodged by the respondent number 2, which is reproduced below. FIR, okay, is not. Twenty-one and pursuant to the lodging of the aforesaid FIR, Dhemaji PS case number 45
4521.
454 of 21 under section 420/406 IPC was registered and investigation commenced, culminating in the filing of the charge sheet against the present petitioner. So, the learned magistrate took cognizance of the offense under section 420 and proceedings commenced. At present, the case is at the stage of trial,
Evidence. Trial.
phase of evidence. Comma. Learned counsel for the petitioner submits that it is apparent from the FIR itself that the dispute is purely of a civil nature. Furthermore, learned counsel has drawn the attention of the court to the documents annexed to the instant revision as annexures fill-up letter to show that the payments have been made to the firm. Namely, what is the name of the firm?
If there is,
Your firm.
you're from Dihang Engineering Private Limited, not Farm Lordship Company
Yeah.
Private.
The
Dihang Engineering Private Limited.
made to Dihang Engineering Private Limited. Where is that at page?
Is 55.
Huh?
Is 55.
You'll find the name at page 55. Dihang Engineering Private Limited. And not in the private account of the present petitioner. Yet, in the charge sheet, there is the said private limited company has not been made a party. Stroke accused. Is the further submission of the learned counsel for the petition that the complaint regarding non-supply of material is baseless, as the petitioner has supplied the materials which was contracted for. In support of his aforesaid submissions, learned counsel has for the petitioner has relied upon the decision of the Honorable Supreme Court in Lalit Chaturvedi and others versus State of Uttar Pradesh and another 2024 0 Supreme SC 190 it is here. Wherein it has been held as observed as follows, para 5, 6, and 7. Para. A bare perusal of the FIR makes it evident that the dispute is purely of a civil nature. Even if the allegations made therein are assumed to be correct, an offense under section 420 read with section 415 IPC is not established in the absence of deception by making false and misleading representation, dishonest concealment, or any other act or omission or inducement of the complainant to deliver any property at the time of the contract, the execution of the contract, time of execution of contract. There is no such allegation in the instant FIR. Para learned counsel representing the respondents has submitted that the petitioner is a habitual offender and that other cases of similar nature, including under the Negotiable Instruments Act, are pending against the petitioner. However, full stop, in the view of this court, even if the contention of the learned counsel for the respondent is number 2 is taken to be correct, the said cases being similar in nature would also be regarded as cases of a civil nature. Full stop.
Lordship, if there another case is not NI Lordship, but they are in criminal code only, Lordship, or civil nature.
No, he is mentioning some NIA.
Yes, NI is also pending.
NI pending.
All right, I have said other cases.
Yes.
Where having regard to the aforesaid discussion and considering the facts of the present case in the light of the decision of the Honorable Supreme Court referred to above, I am of the view that the instant proceedings pending before the learned court below amounts to an abuse of the process of law. Therefore, its continuance cannot be permitted. Accordingly, the see from the custodial proceedings number 12 so pending before and are hereby quashed. Revision stands allowed accordingly.
Much obliged.
Published.
It is fixed on 12/2012.
Please the matter along with
7.
3678 of 25 on what is the date?
3/12/20.
3/12. Yes.
Since 6 lakh rupees dispute, Lordship, if possible to send the matter for mediation. Possible.
Yes.
Pilot can,
Huh?
pilot.
Had learned counsel for the petitioner. Learned counsel for the respondent number
Respondent number 2.
2 also had learned additional PP. Upon perusal of the record, it appears that there is possibility of settlement to mediation. Accordingly, the matter is referred for mediation. Registry to do the needful. Parties are directed obtain further instructions from the registry. Is the matter again on 4 weeks?
Any
After
date,
4 weeks, huh?
Any date
After
not paid, it's left. Therefore, I
Mediation. January.
All right.
Interim.
Hmm?
Interim.
already interim order passed earlier to continue till the next.
Okay.
I appreciate it. Learned Friends Trust Lordship, and yet to receive the copies of the criminal revision.
No, look, we have also got the copy. He has also been appeared before court.
No, Lordship, delay was condoned, Lordship, on 16/5.
Hmm?
Delay was condoned in the I was disposed of on 16/5. Matter has come up for the first time, Lord. I mean, the copy.
How has it come up without service of copies?
So I filed written objection in the I Lordship. My name has not.
Serve a
reflected.
copy, your lordship. Today it's serve a copy.
Learned counsel appearing for respondent number.
Mission Lordship.
Huh?
But from that I have submit. From this honorable court, there is a direction to continue
No, there-
pay the maintenance Lordship.
Regarding other consideration will be taken after the receiving the final disposal of the this revision petition. Your lordship.
There's a
I will
clear
serve a
di-
copy.
There is a
Today
clear
itself?
direction from this honorable court, Lordship, to continue with the maintenance, Lordship. But he did not pay a single money, Lordship. Till
So that
date.
is the course of the revision petition enter reveal all the things.
This direction
I
cannot
will
be done
serve
with
a
the
copy to him before this honorable court today itself. And thereafter the matter may be considered.
kindly
And
take
date
up
will be fixed.
item number 11, Lordship. In item number 11, there is a direction, Lordship.
And your lordship, I have
If you contend you do not have the copy, only direct to him to serve the copy and list. It
Lordship.
will not go into the rest of the matters.
lordship.
There is an interim order that may be continued, Lordship. Item number 11.
Is it till a fixed date?
There is no fix.
Then what is to continue?
Lordship.
Just continue time by time to time, Lordship.
Is the interim order until a fixed date for a fixed date?
Till next January.
Hmm?
It was directed to be fixed till next January.
What is the interim order?
The order dated 10/1 was kept in abeyance by this honorable.
In this case, notice has been issued. IA, your lordships. This case, I have received.
All right,
the
11
copies.
in learned counsel for the respondent submits that he has not been served with copy of the revision petition. Can be supplied to him in the course of the day. Is the matter again on? This one.
Lordship.
In 11, you write interim order passed here to continue till the next.
Right, Lordship.
Your lordship. Pass up.
But my concern.
Very wrong, your lordship. Very wrong practice.
We're on 13 right now, so please don't butt in. Let the item be over before you come. We didn't ask you to keep sleeping. Yes, in 13 records of criminal petition 491 of 21 were called for. Is it there? Yeah. Right after some time.
Obliged.
Updated CD was called for. Petitioner is an interim that we have not received.
Updated CD not received. Again, also interim order passed earlier to continue. Next date of listing.
15th of December. And
Highly obliged.
Please, your lordship. My lord, application under 483 of the BNS, regular bill application. My lord, we will find the FIR in page 19.
15,
Received.
Your Lordship, surcit has been laid.
My lord had given me the privilege of going on by order dated 4/11.
Yes, so what do you want now?
My lord, we make the interest absent. Because my lord, the primary reading of the FIR itself will not reveal any cognizable.
May appear before the trial. Are in accordance. The surcit has been filed.
My lord, there is no the allegation is under 3184, 420. If it's not there.
No offense appears to be made out. He was found in possession of a
My lord,
hard learned counsel for the petitioner. Order dated 4/11/25, first second era. He submitted that charge sheet has already been laid by PS number
79 of 2025, dated 31/10.
the allegation against the petitioner is that he was found loitering in the Bongaigaon railway station. And a boat shaped piece of golden metal was found in his possession. Because of which he was arrested. Having regard to the nature of the allegations and the fact that the investigation is over, it would not be necessary to take the petition into detention. Accordingly, the prayer for pre-arrest bail is adopted. The order of interim pre-arrest bail.
this is the regular bill application.
Regular.
Yes, Lordship.
So, order of interim bail dated 4/11/25 hereby made absent. Further provided the petitioner shall regularly appear in the trial if one comment petition is according. You write detention, further detention is not necessary. Yes,
Page 11 is the FIR, my lord. Here the names of only one person of the applicants is there. That is Khanda, Javid Khanda. And only on the basis of suspicion. And they have produced one teaser list that Lordship may kindly see, page 17. Page 17, the following this exhibit is produced before me by the IO Inspector Ajay Kumar Saha, OC Manipur PS in connection with Manipur PS number so-and-so. Description of the seizure item, file number so-and-so, money received in the name of Gulab Hussain, amount rupees 1,000. Similarly, Lordship would see it was produced by IO. This was not recovered from us. And secondly, my lord, the incident happened in the year dated 18/11/23. From the teaser list it appears, and the case is of 25. So it appears prima facie that nearly 2 years later the case has been filed when this Biril Ashish Sena was not an banned organization. And moreover, this person, petition number 2, has joined only in this organization in September 25. So on the day of alleged offense, he was even not a member. And nothing was seized from this person. And they are in custody since last, my lord, 22 days. My more prayer is this, my lord, they are insufficiently, they are in custody. They will cooperate with the investigation. Kindly grant us stay.
Yes, PP.
My lord, we have received the case therein, my lord. First of all, my lord, the accused person, my lord, they are the FIR name accused number 3, 4, and 5, my lord. Now, my lord, yes, FIR name accused, my lord. Page number 11, lordship may kindly peruse.
Body of the FIR only Khandap, David Khandap is there. Yes, their rest of the names are given only on suspicion.
Secondly, my lord, the person from whose the money was extorted, my lord, their statement has also been recorded, my lord. They have identified these 3 persons, my lord. Out of fear, my lord, till, my lord, before lodging of the FIR, my lord, they could not inform anybody because, my lord, they were threatened. Even, my lord, when the money was not paid, my lord, they said that we will stop your business. Out of fear, my lord, they have not been able to inform to anybody, my lord. So they have implicated, my lord. There are sufficient materials, my lord, and they, my lord, received, my lord, which was given to them, my lord, that is also collected, that is also seized, my lord. So at this stage, my lord, I am opposing.
But first thing in the serial list, there are no signatures of the present person. Secondly, my lord, we are in custody since 22 days. So considering their period of detention, they may call their local person.
Okay, my lord, investigation, my lord, several other accused persons yet to be arrested, my lord. So if it is, my lord, release them on bail at this stage, my lord, will hamper the further investigation.
Lord,
Not
actually,
at this stage, my lord.
but my prayer.
Okay, pass over the CD, will examine.
My lord.
All right.
Happy to look. The Shanmari PS case. Just short.
Hmm.
Was around 12% granted.
Yes, what are these orders?
The bail order, orders granting bail. I'm not named in the FIR. Can you turn to page 17, the forwarding report.
Present, who are the present petitioners?
Present, that is what I'm sure. Page 17, same forwarding report. Use number 2 and 3 in the forwarding report. 7. All the other persons in from the state forwarding report.
Anything directly against them?
My lord, case that he received, my lord, there is one eyewitness, my lord, who was along with the accused, my lord. And he has implicated, my lord, they are both are, my lord, they are brothers, my lord. He said, my lord, Vishal Chakraborty, my lord, one of the petitioner, my lord, he kicked him from back. The victim, my lord. And regarding the Varun Chakraborty, my lord, he said he was in the, my lord, group, my lord, but he has not seen, my lord, assaulted. As far as Vishal Chakraborty is concerned, my lord, he has so much.
Only that.
He has only that, my lord. That.
So how many days now?
49 days.
Order dated 10/11/25. Petitioners হ'ব। বাকীখিনি একে para 5 second line. However, submits that there is some incriminating material against. Which one? Petitioner number two.
Petition number 2.
Number 2, my lord, Vishal.
Petitioner number 2. On perusal of the CD, the material does not appear to be a very grave one. As regards the petitioner number 1, there appears to be no specific material. Baki paragraph just 49, 7 days.
49 days.
9.
My submission and objection.
Yes, your submission on the basis of the CD has been recorded.
Obliged, my lord, fairly obliged.
May it please the Lord. Here, my lord. FR at page 10. FR at page 10, your lordship. The litigation is against the number 1.
Notice to respondent number 2
Respondent
appeared.
appeared, my lord, and my lord, they have filed an affidavit also. Regarding the 2, they may not have any objection because, my lord, is litigation against the petitioner, my lord. The brother of the main accused, my lord.
Only one petitioner is there.
One petitioner, but my lord, the accused number 1, my lord, allegation is against the accused. One was granted bail by Honorable page 8. Then matter number 2 was outside. Hearing till sounds foreign. He has applied for it.
Where is the order granting bail?
Page 18. Relevant portion, page 9. And so, my lord, is not against the pit. However, cognizance was taken, but FOXO is not against present pit. That lottery will get it at page 35. FOXO is against for one. Carrying FOXO.
Charge sheet is against all.
Lord,
Charge sheet is against all of them.
charge sheet. Petitioner is shown as an absconder.
Where is their affidavit?
Maybe in the record, you'll
I see an affidavit. One. Yes, PP.
Sarchitar, my lord, in the Sarchit, my lord, he has been shown absconder, my lord. But as per the FIR, my lord, there is no direct implication against him. He has
Even in the charge sheet, has anything been mentioned against him?
not specific, my lord.
but my lord, the cognizance is not taken against him, my lord, under the FOXO Act.
My lord, Lordship may peruse page number 32 and 33, my lord.
APR, my lord, you face the trial, your lord.
So page number 33, my lord, that down portion investigation details, my lord.
Page
Lordship may
33, my
kindly
lord.
come to, my lord, number 6, my lord. Dot number 6.
Dot number 6, your lordship. Page 33, dot number 6, again. State.
The materials, my lord, as far as this.
Main accused has been released. What is the point now?
APR,
And against him, there is no cognizance under section 4.
'96 is taken, my lord, against.
Hmm?
96.
BNS.
Yes, yes. '96 is, my lord, procuration of sile, my lord.
Hmm?
Procuration of sile, my lord.
That is not applicable.
All right. Third, Mr. Order dated 19/9/25, page 19. 1, 2, 3 it add করে দিবা. It is further submitted that the present petitioner, who is the brother of the main accused, that is Muqsidul Islam, is not involved in the offense. And the main accused has already been granted bail by this court by order dated 19/9/25 in BA bail application number 266/25. In the said case, this court had observed, in the said order, that this court had observed that the victim was 17 years old and on the verge of attaining majority, and despite allegations of forceful sexual intercourse, considering the entire story of the prosecutrix, there appears to be an element of cooperation. There the charge sheet filed against the accused it appears that the present petitioner has been implicated on the basis of the statement of the victim under section 183 PNSS. Wherein it is alleged that the present petitioner had helped the main accused in taking away the victim. It also appears on perusal of the charge sheet that, as against the present petition, the IO has invoked section 140 within bracket 3 PNS and section 17 of the POCSO Act. An affidavit has been filed on behalf of the informant, wherein it is stated that the informant has no objection to the grant of pre-arrest bail to the present petitioner. It appears that in bail application number 266/25 as well, it was submitted on behalf of the informant, submitted by learned counsel for the informant, that he has no objection to the grant of bail to the main accused. Considering the aforesaid facts and circumstances, and taking into account the stand of the informant in both the cases, as well as the fact that the investigation is over and the main accused has already granted bail, pre-arrest bail is allowed. Same event of which arrest 20,000.
Oblige, your lordship.
This recording. Check.
May I plead your lordship? Lordship, it is a regular bail application, lordship, and I am in judicial custody more than 150 days, lordship. Lordship, I am charged with section 1031, 109, 3293, 1172, 328, and 35 of NS, lordship. Lordship, after framing of the charge by the trial court, two sections were discharged from the charge, that is, lordship, section 117 and section 28 of BNS, lordship. Lordship, and two new sections were added, lordship, section 115 and 38 of the BNS, lordship. Lordship, I want to read the summary of investigation, lordship. Lordship, kindly go to the page number 32 of the search sheet. Page number 32, lord. The investigation has reconstructed a sequence of events that transpired on the fateful night of June 14, 2025 at approximately 11:30 p.m. within the residential compound shared by the families of two brothers, Nilesh Wright. A brutal and premeditated act of violence unfolded. The accused person, accused one Sri Hemant Talukdar, and his wife, accused two Srimati Junali Talukdar, driven by a long simmering and acrimonious dispute over ancestral property, criminally trespassed into the courtyard of the deceased, Sri Vishnu Talukdar. Accused one, armed with a formidable weapon, a solid iron rod, approximately 4 feet 4 inches in length, initiated a vicious assault. His primary target was his elder brother, the deceased Sri Vishnu Talukdar, with lethal intent. Accused one struck Vishnu Talukdar on the head, causing a catastrophic injury. As the deceased years-old son Sri Devasis Talukdar courageously attempted to intervene and protect his father, accused one turned his fury upon him, striking the boy on the head with the same iron rod and inflicting a grievous wound. While accused one was carrying out his deadly assault, accused two, Srimati Junali Talukdar, actively participated in the criminal act. Eyewitnesses' accounts established that she assaulted complainant Srimati Puma Talukdar with a wooden stake, thereby ensuring that no one could effectively aid the primary victims. The violent commotion and terrified the screams of the victim's family pierced the night's silence, altering neighbors who rushed the scene. They arrived to a horrific sight. Both Sri Vishnu Talukdar and Sri Devasis Talukdar were prostrate and bleeding profusely from severe head injuries. With the help of these neighbors, the victims were rushed for medical aid. However, the injury of Vishnu Talukdar was too severe. After being referred from a local facility, he was admitted in a critical state to Tignas Hospital of Kamalpur, where despite of medical efforts, he succumbed to his injuries. He was formally declared dead at 30 hours on June 5, 2005. His son Sri Devasis Talukdar survived the attack, but required 12 stitches to close the deep one on his head. Hence the case, Lordship. Lordship, it is not a murder case, Lordship. As mentioned in the search sheet, Lordship, it is an accidental death, Lordship, by fight between two brothers regarding their ancestral property dispute, Lordship. Lordship, no independent eyewitness is present, Lordship, in the search sheet except the witness of deceased wife, son and daughter. Lordship, kindly go to the page number 30, Lordship. Page number 30, Lordship. Last para, Lordship, you see that Pratima Talukdar, informant wife, informant herself, and Devasis Talukdar is informant son, and Neha Talukdar, informant daughter. Lordship, these are the only eyewitnesses, Lordship, and these are the actually, Lordship, these are the interested witness, Lordship. Lordship, moreover, the weapon which was seized, Lordship, was not sent to the forensic lab. Only by a simple reason, Lordship, on the date of time, there was a heavy rainfall, and marks on the weapon may be washed off, Lordship. Lordship, marks on the weapons present or not can only be decided by the forensic authority, Lordship. Not
Lordship
the
is hearing a bail application, my lord. These are the matter of trial, my lord. He is unnecessarily wasting honorable.
Lordship, no, this is the argument. Lordship, without expert opinion, how can we identify the murder weapon? Lordship, I want to read the relevant portion of the search sheet. Lordship, kindly.
Is there any law that says that the murder weapon has to be recovered?
Yes,
percent.
recovered, Lordship, but murder weapon has not sent to the FSR.
In 80% of cases, we do not find the murder weapon. Does that mean that the case will go?
Yes, yes, Lordship, but Lordship, no independent eyewitness is also present, Lordship.
When more than one eyewitness have squarely implicated you, a brutal assault, you're saying it's an accident. Evidence is there before the court now. It is not as if we are looking only at the police statement. You've gone through the deposition.
Yes, my lord. I have flagged the, my lord, this one, the eyewitness, my lord, his son, my lord. Because the deceased was, the victim was
Before
killed, my
the
lord.
court, at the trial. Trial is commenced.
The trial not commenced, my lord.
I think there was an
It is
order.
fixed for on 16/1/2023, it was fixed for evidence, my
For
lord.
evidence.
7/11/2025 charges frame, my lord.
Wait till the main witnesses have been examined. After that, you come. You can
Yes,
consider. Adlan it comes to the if here is called has been if allegation against the petitioner that he along with his wife trespassed into the residential campus of the government and assaulted her husband and son with iron rod, as a result of which them sustained grievous is their head, and out of the two injured persons, her husband succumbed to injury. The charge sheet has been laid. Charges under section 302.
My lord, 103, 109, 329(3), 1152, 238(3), in bracket 5.
Have already claimed by the learned court of case. Since gone through the PCR, there is sufficient present petition the eyewitness team petition above, as well as grave nature of the alleged of prayer for bail rejected.
It on the last occasion, Lordship has heard it, my lord, and Lordship has directed us to produce the case diary. Now we have been,
Come, my lord, I think.
we have
But
been informed.
Lordship has not called for the TCR, my lord. There's got that case, my lord, where man 80. Kind of barge, your lordship. One, the cold spit he purchased, my lord, one, my lord. And, my lord, provide logistic support. On considering the detention, my lord, that day I have prayed, my lord, yesterday. They took 4 days. Then the order of the learned magistrate, my lord, reflects, my lord, their role, my lord. The petition number Nur Hussain, he has purchased. Possible, my lord, provide logistic support, my lord. Considering the detention period, my lord.
Now, you are the purchaser of the
One petition is the purchaser, my page 25, my lord. Page 25, my lord. Second paragraph from the order of the magistrate, my lord, petition. Page 25, that Babul, last line, second paragraph. Silver ornaments are sold to them. Babul Sonai alias Nur Hussain, my lord.
present petition is
One Nur Hussain and one Tafazul.
Tafazul.
A Tafazul allegation, my lord, that is at the order of the learned magistrate, my lord, at page 24. Last paragraph. Provide logistic support, my lord. So, my lord, my humble submission for a lordship, my lord, if you believe also, my lord, that my lord, T314, my lord, punishment in 90 days may not be attracted against them, my lord, because they have not committed, my lord, one purchase, one, my lord, help, my lord. Moreover, my lord, 80 days as on date, my lord, custody. Further custody may not be required, the lordship. Any condition, my lord, lordship has granted bail to the, on that day, my lord, similar case to this person.
Charge sheet has been submitted against all.
Yes, my
All
lord. I agree,
my lord. Petitioner number one, my lord, he purchased, my lord, that is the allegation. But two, my lord, he provide logistic support. Detention, my lord.
What is this new system started, PP?
My lord.
This big stamp over the Assam police so that we
Yes.
can't read what is written in.
It has come in quite dark, my lord. Otherwise, I have seen what it has come in the light.
According to you,
Lordship.
you just submitted that 90 days may not be attracted.
My lordship, lordship. Against the petitioner number one, it is not at all attracted because he is the purchaser, my lord, when there for commission of that offense. And petitioner number two, as per the order of the landed magistrate, my lord, he also didn't provide help, my lord, member for commission. That is at page 24, it is reflected. The landed magistrate has written everything in.
So according to you, which provision is attracted against them?
My lord, the others, my lord, others are attracted, my lord, 305 is there. Or receiving stolen property, my lord. And moreover, man, I'm paying mainly on the detention period.
So all right, hard learn for the petition. And keep it. An application that points to. As per allegations in the FIR, three unidentified miscreants broke into the Sanghasri Kali Mandir at Bhekiajuli and stole valuable gold ornaments, clothes and cash. And the value of such property has been estimated at approximately 3 lakhs. And the incident which took place on the night of 28/8/2025 has been captured in the CCTV footage installed in the nearby building. In course of investigation, the present petitioners were arrested and it appeared, and subsequently the charge sheet has also been submitted. It appears from the material that accused Noor Hussain was the purchaser of stolen property, and the other accused, that is petitioner number 2, Tafazul Haq. First petitioner number 1, Noor Hussain. provided shelter and logistical support to the co-accused. It is urged on behalf of the petitioners that they were not directly involved, and Learned Council has laid stress the period of detention of how many? 82?
82.
82 days
28.
undergone by the petition. Praise for bail. Having regard to the period of detention, completion of the investigation. Further detention of the petition cannot be warranted. Accordingly, the prayer bail is allowed. To see.
CGM solid to test.
They will participate regularly in the trial.
My submission may be recorded, my lord. Charge has been submitted and there are sufficient materials collected. my
Yes.
lord.
The other hand,
Charge number is, my lord, 248.
it is as the basis of sufficient incriminating against.
PLF interim.
You have received?
Already charge is submitted, my lord. Please.
What is the allegation?
Allegation is this. Her husband committed suicide by hanging house. Therefore, the father-in-law filed a further. Direct
Yes, it seems from the interim order itself that prosecution does not have much to say.
Yeah, my lord, now charge has been submitted. Let her appear and face the trial.
Anyway, from contents of the earlier order itself, it does not seem that arrest is necessary. Again, no necessity of taking custody. Hard order dated 13/8/25. First, second. This is on behalf of same. Allegations as in the FIR. There are two petition Again, order. Same order dated 25. Rajay Burwa learned. NLPP submitted that the first it has been submitted.
Right, case number 110/2025, dated 28/8/2020.
The petitioner may be asked to face the trial. It appears from the record that there are some incriminating materials against the accused petitioner, but there is no mention about any quarrel the day of the incident when the deceased committed suicide. The postmortem report also reveals suicidal hanging, and no other injuries are found upon the deceased. Pursuant to interim protection granted by this court, the petitioner had appeared. IO. And her statement was considering the above fact that the charge sheet has already, investigation is already over. There appears to be no necessity of taking the petitioner into custody. Order of interim pre-arrest bail dated 13/8/25 hereby and absolute, subject to the condition that the petitioner shall face the trial regularly if one comment stands allowed according.
Absolute Tihal, her appearance before the trial. Absolute, my lord, her appearance before the trial.
If we make it absolute, then can we say that?
My lord, she have to appear before the trial court.
She has to appear. We have said she has to cooperate with in the trial, appear regularly in the trial.
For case that he received. It is not up to date, my lord. Statement of the accused is not the case diary, my lord. He was granted interim.
Last order was also same. Learned additional PP means that updated CD is not available. Hence call for the updated CD.
So that is around 12 of 12.
First say none appears.
Worship cases, they don't, very. Earlier that.
Case diary received, my lord, along with the injury.
A dispute.
Yes, what is the injury report?
My lord, injury report, my lord, grievous, my lord. Two persons sustained injury, my lord. Tofiqul Islam and my lord Afia Begum, my lord. Both the injuries are mentioned as grievous. My lord. cases also are implicated there.
There is a cross case lordship, and a dispute with regard to the share of a lordship will proceed to a plot of land. If family lordship, they will cooperate with trustee by submit lordship custodial inquiry. They will cooperate.
That argument can be made in every case, but we have to look at the nature of the offense as well. Where is the injury? Which part of the body?
The face, my lord, nasal portion. In respect to Sofikul Islam, my lord,
Nose. Nose.
nose.
And
And my lord, this Safia Begum, my lord, extra of hers, Elatepal, my lord, that medical word has been used.
Hmm?
The medical word has been used. There is also fracture, my lord. Bicartical displace fracture of meta
oh,
and metacarpal bone.
thing in the hand.
Maybe my
It is stated in the
hand.
Third learned counsel for the petitioner. Application. For allegation made in the fire, the accused persons assaulted the victims and caused previous injuries upon them. Full stop. It is submitted on behalf of the petitioners that what took place was a mutual quarrel rising out of family dispute. Granted additional PP upon perusal of the CD and injury report submits that the same indicates previous injuries on the victims. So, however, it appears that one of the victims sustained fracture on her hand and another on the nose, that is on non-vital parts of the body. They have appeared.
Their statement is not in the case diary, my lord.
Appeared, Lord.
Hmm?
They appeared.
And I submitted on behalf of the petitioner that pursuant to interim protection granted by this petitioners had already appeared before IO and their statements have also been duly recorded. Considering the aforesaid facts, circumstances, the custodial detention of the interrogation of the petitioners may not be necessary. Accordingly, therefore, pre-arrest bail is allowed. The order of interim pre-arrest bail dated 25/9/25 hereby made absolute. Petitioners are directed to cooperate with the investigation and shall not hamper or the investigation tamper with the evidence. Hence disposed of accordingly.
Obliged.
Your lordship, 26 and 27, your lordship. Steps need to be taken, your lordship.
Hmm?
Because I have filed additional affidavit, so steps could not be taken, your lordship. So 1 week time I can leave. Because I was suffering from illness, therefore I couldn't take. Oh, okay. Subsequently POXO added, and therefore
Yes, learned counsel for the petitioner prays for 1 week's time to take steps.
CD is also there. CD is also.
CD may kindly be retained.
Oh, CDA, if you take steps, it will have to come back, and then how long will the CD be retained?
We'll send back it.
To take steps on respondent number 2. Accordingly, prayer is allowed. TB, return back. Is the matter again on when the order passed. Continue till the next date list again on.
15 of
15 lordship. Plus.
Available. Is all for the update is. Six. Is an egg. Like first. They take yours. They have also highly and the yeah, attention to only that is why the
Yes, PP.
Should, petition was rejected. That is 2020. Thereafter, Lord,
When 1825.
yes, Lordship. Thereafter, Lordship, there is a note from the IO's note that in the course of investigation, several attempts were made by the to interrogate the FIR named accused person, but they have not appeared before the IO, Lord. And WT message is also sent to the officer in charge of Chicago respect of the appearance of the named accused persons in certain situation. No response has been received till date. The 2 grounds has been taken by the rejection of the earlier.
one is just there is some transaction to be entered.
That is, they have to come and say.
Lordship.
Earlier in jail petition, some transaction in the government and the public group. Earlier petition, we have not. Initially, the informant come across the public group and then it's got
No, what you are submitting is that they have come into some kind of arrangement, and it is they who have to come and say.
1 lakh public group.
Where is that? Where do we
Yeah.
know all that?
2,000 public group.
Several attempts have been made by the investigative. There,
They may be given, then I approach the IO.
Sorry, it was rejected matter.
The recovery of the money, there is an agreement and there is a.
Sorry, we do not find any ground to alter what we have said earlier
Lordship,
while rejecting the bill. Provincial learning. Order dated 1/8/25. Para 1, para 2. Para 2, sir, this is an application. This is second application. Earlier application filed by the side AB 14865 was rejected by this court by order dated 1/8/25. The previous bail application was rejected by observing that the custodial interrogation of the petitioner was necessary inasmuch as sufficient material was found against them in the CD. And hence it was not a fit case for grant of pre-arrest bail. In the instant petition, no new ground has been made out to the satisfaction. Accordingly, instant petition also stands dismissed on the CD.
May I please, your lordship? I beg to make item number 30, my senior on text other court. So this matter may be passed over for time.
You have written it down. All right. Wait for some time.
Another matter.
This is another matter.
Item number
Huh?
1, please.
One. Yes.
Hello, this is passing. By this, my lord, another for it, my lord, lordship is, this one is paying for passing of the or the case number, my lord, Nagaon PS 1811, and the a search sheet that has been filed on 38/2021, and subsequent taking cognizance of the case date on my lord 4/9/2021. That is same Nagaon. But in this case, fact of the case was that, my lord, the petitioner used, but he is a bachelor in a bachelor in dental alternative science. It is a recognized course. It is alternative medicine council. There is separate council under which he has been given
Dental alternative science.
alternative science. It is the another course being the alternative is a part of the alternative medicine.
Alternative, we understand. Dental alternative, what is that?
It is the term is
All right. Yes.
so on that he is a validly obtained his degree from the Sialda the Medical College of Alternative Medicine in year 2003 on his valid registration number 12356 dated 77 to 3. Subsequently, he has obtained the registration.
Is there any statutory cover for this? Is there any government recognized body
Yes,
controlling this?
There is no dispute that I am not not a qualified on this alternative science in bachelor of dental alternative science. There is no any dispute is that, my lord. Subsequently, I obtained the BDS also from this is college called the Rana Pratap College. It is from Kanpur, and that has been affiliated to another university, my lord. But after obtaining my bachelor degree, I registered my as a dental BDS as a under the Dental Council of Assam. And regularly I was practicing after the obtaining this certificate registered. I also started practicing simultaneously only bachelor dental in alternative science. So during that time, what happened? Some allegations were made against me. Not only that, is the first time, the earlier occasion also some allegation was made. That was duly conducted by the authority concerned. I was allowed to practice prior to my obtaining the BDS in the line of the alternative. Now, when the allegation was made that on the basis of that allegation, the director, this is registered, Dental Council of Assam, has called me to show all the documents and come with all the documents, and I have accordingly produced all documents. And being not satisfied, he wrote a letter to the college where from I procured the BD. So initially, by letter, they initially stated that I have not the student, I was not a student of that college, but immediately followed by another email that was specifically stated that that letter, whatever was issued, that was by mistake, but I was obtaining the degree from the same college. But whenever that came to the knowledge of the registrar, but there was a mistake in the spelling of the college. That is instead of college, there is a cottage. So advised to bring the hard copy provided by the hard copy by the concerned college, but that was not done. Then they approached the Dental College of Dental Council of India. So to verify whether where from I obtained a 1 year internship course after the obtaining BDS, whether that college is covered under the Dental Council of India to the internship. So they said that that was a general college, so that is not recognized dental internship. So accordingly, the Dental Council of Assam has de-recognized my this place. So after that, my lord, allegation was that I was doing the practice at the same line, the BDS in Nagaon. And on the basis of that, they lodged an affair initially at Bhangagarh police station by the registrar Dental Council of Assam. And during that continuation of that case, second affair was, not initially that affair, that another allegation was made before the DGP. On the same allegation, same content, and by the same person. And that DGP forwarded the case to the police station Nagaon to register a case. So accordingly, second case was raised on the same facts, by the same, on the basis of the complaint lodged by the same party against the same accused person. Contents are nothing is not any deviated from the first one to second one. The entire content is same. So now, on the basis of that second affair being lodged before the Nagaon police station, I was arrested. In first case also I was arrested, then I was released. Then second case also I was being arrested and I was released. Now, my lord, after this things, I came for the quashing of the second one on the ground that as the first ones have already been registered and the organized has been taken, case has been proceeded in Guwahati jurisdiction. Is on the same facts, the second case cannot be maintained. So I, invoking the decision rendered in the Bhajanland case, in category number 7 particularly, I mentioned in clause number in ground 10 of my this quashing petition. The second case, my lord, that cannot be maintained.
Yes. Where is the FIR?
FIR 8 page, my lord, lordship, annexer. 2, my lord. Or,
Page.
my lord, annexer 3, my lord.
Page.
Yes, yes, my lord. This is, my lord, the type copy of the FIR. It is annexer 5 at page 30, my lord. Page 30. It has been written by, submitted by the registrar, Dental Council of Assam. Contention, my lord, was that we have received a complaint from Dr. Well, his name was not visible, so once Dr. Das Jagirut, a qualified registered dentist, and that Mr. Moinul Haq, the practicing dentistry, projecting himself as a BDS, SLR of dental surgery, graduate since several years, graduate since several years, he obtained a registration from this council on 21/9/2019 in the fraudulent manner, submitting the manipulating the forged document.
Which page are you reading?
My lord,
Page?
this is 30.
Yes. This is to the DGP.
Yes, on the basis of that, my lord, the case was raised.
Second one.
Second one.
Okay, that we have seen. Where is the first one? First FIR?
First one, FIR was not there, my lord. Here is what specifically mentioned he himself. If lordship will go
No,
to
without seeing the first FIR, how can we say this second FIR pertains to the same facts?
This is the same text, my lord. Because I probably when a record was called for from this first one. As per the last.
Yes, all right, go on. Let's see that.
This mentioned, my lord, directly he is mentioned the first FIR was lodged before the Bhangagar police and he was arrested. And I have gone through my lord, the first FIR, the content is same, allegation is same, my lord. Same facts was there also. On the basis of the complaint received from the Dr. Das, this and this no happened. The same thing has been again elaborated in this FIR.
So you are on Nagaon PS case 1811 of 21 now. Yes.
And so far, my lord, here is a specifically one allegation is there that I am, my lord, mentioning my registration number. So whatever number is, my lord, it is given. Actually, this number I is authorized to use. This is, my lord, the number relating to the lordship will come to page number 32. And specifically mentioned, my lord. So I am on that also. In this prescription, he quoted his fake course registration number PR548. So, my lord, this number is not relating to the Dental Council of Assam. This is, my lord, by relating to this council, the alternative council medicine, my lord, issued the registration in respect of me, by which, my lord, I allowed to practice in the dentistry under the, my lord, alternative science. It is, I have annexed at page, my lord. Next are 1. At page
Which number are you referring to?
My lord, this is the page number 32, lordship.
Yeah, 32.
Yes, first come to page number 32. The content of the FIR I am reading. He said that I have used this number in my prescription. I am not entitled. But 32 of my.
Yes, all right.
It is, my lord. It is the last but one paragraph, my lord. In the prescription, he quoted that the fake course registration number PR 548.
Yes, 548, that is the allegation. So
Now Lordship come to my lord in little forward, page number 26. Annexure 1.
yes,
Where my lord, my registration number is given by the Northeastern Council of Alternative Medicine, my lord. Lordship will get the practicing registration number, the bold head, my lord,
yes,
where it is specifically stated, my lord, NECAM 548 PR.
five four eight.
Yes. So, my lord, this is a valid my lord, the registration number issued by the alternative medicine, where under which my lord, I can use, I can practice. My lord, there is no any bar, nobody has prevented me practicing in this line, but not as a BDS. The pronunciation is like my lord, BDAS or BDS. My lord, it is presumed to be same. This is the difficulty. So, whatever allegation is made in this my lord affair, it is also not correct. But the police, my lord, during the investigation, they have also wrote a letter to the, my lord, the registered alternative council, alternative medicine, my lord. The lordship will get this, my lord, this reply that's been given by the registered in response to the letter to the police. It is page number, my lord, 52. Whereby, my lord, the question answers, they answered the all queries made by the police, and nowhere it is, my lord, stated that I am not the, my lord, the validly registered, my lord, practitioner under this council. Only my lapse was that on the day of the, my lord, inquiry, although the day of the complaint, my lord, license was valid during that period, only for the renewal part was not there. After the subsequently my renewal was coming, so my lord, he said, when the inquiry was made and response was made on my lord, the 14/8/2021. By this time in 2020, my lord, I was my lord, supposed to renew my license, but that was lapse only lapse, my lord. So it is specifically mentioned in reply number 6. Every registered practitioner lordship will got to my lord the last from the bottom, first, second, third, fourth, fifth, sixth line, my lord. Reply to para 6. Every registered practitioner under the Northeastern Council of Alternative Medicine should renew his her regular every year before 31st March 2000. Please see the rule 5 of the PR certificate. But as per the record, the renewal is pending, and moreover, the
Anyway, do we need to go into that? Because
my
your
lord, because
contention
no-
is the,
my only submission is that, my lord. So far, my lord, there is a 2 degree. I am, my lord, practicing initially, although, my lord, in BDS, after my cancellation of registration, I am totally abandoned. But so far, my first degree, BDAS, my lord, I am a valid practitioner. I am having the license. I am regularly practicing. Nobody is, my lord, putting any question on that me. And moreover, my lord, in the earlier 2 occasions, the lordship will get the annexure 10 at page 50 and annexure 11 at page 51. It is very, very important, my lord.
is 51.
One is 50, my lord, 50. Annexure 10.
Verification of documents.
Yes, my lord. It has been issued by the Joint Director of Health Services, whereby, my lord, he verified my all documents regarding my alternative medicine. I was allowed to practice. And second, my lordship, in earlier occasion also, in Annexure 11 at page 51, certain allegation was made regarding my practice in 2006, where also I was found, my lord, everything was valid. So now the question is, my lord, after cancellation of my registration in 2019, my lord, whether I am continuing practice or not. So I have never been practicing in any BDS line after that. And moreover, once the FIR has been lodged in the Bhangagarh police station, and that has been registered by the same complainant on the same facts, whether that is second affair in the Nagaon that can be continued or not. The Supreme Court says, while the Bhajanlal already I have stated that the under which circumstances 7 category, the lordship and the under the extraordinary power and inherent power has been defined, that they can exercise, the lordship can exercise the crossing power very cautiously. But the case my lord decided, the TT Anthony also I will rely my lord, where the complaint in respect of the same my lord facts, 2 complaints subsequent cannot be my lord survived. In my lord TT Anthony case also my lord, Supreme Court my lord decided in this is 2001-6, Supreme Court my lord 181. Lordship, I am furnishing the book to your lordship, by which my lord page number para 27 and 25. It is specifically stated, but on the same facts, no second affair can, no complaint can be subject. The second should be.
Give the citation.
Citation is my lord TT Anthony versus State of Kerala. Is my lord the reported in 2001-6 SEC 181. Para number 25 and 27.
Yes.
And second case, my lord, the one case, this has been decided by the Supreme Court also in Anju Chaudhary as a state of UP and others. That is on the 13 December 12, my lord. It is reported in.
You have a copy?
My lord?
You have a copy?
Yes, my lord. Please. So here, my lord, this also, I have marked the phases, my lord, in para, where it is, my lord, the 9, para number 9, 9C, my lord. Then again, my lord, the 18. Before that, my lord, see 21. 16 also, my lord. And if 5. TT Anthony case also here relied, my lord. Where it is saying that if the second affair on the same facts, this is not maintained, it is liable to be passed. So my humble submission, my lord, whenever the case is already been pending here, Bhangagar, and it has been proceeded, it already been taken, cognized has been taken. So my lord, the second case, my lord, all efforts should have been made by the government or by lord, this complainant side to bring all these record in one place. But instead of my lord, going to the different place in continuing the proceeding, it is my lord total vitiated in law. So this is my humble submission. The second case cannot be my lord continued. That's possible. And the another case also I relied. This is my lord the Manju case also I had relied in that case. This is my lord. My lord, this is online, my lord. This state of Rajasthan versus my lord Surendra Singh Rathur, my lord. It is also online, my lord, 2025 Supreme Court, online 358. And another also, my lord. Yes, my lord. That is. My humble submission, my lord, this.
You hand over the copies.
And I'll provide, lordship. So far, my lord, the second affair is there, my lord, on the same facts, same contents, and record is there, my lordship. And my lord, scrutinize the because I have already scrutinized the content is, my lord, ditto of the first one and the second from the ditto of the first one. So my contention and my submission, my lord, the second affair, second case cannot be possible. That should be.
Yes.
Lordship, kindly take up the first petition, my lord. 491, 2021. Has been disposed of, my lord.
Yes.
Well, the Lordship kindly, the first FIR that was lodged on 26th of March 2021, page 15 of their petition itself, Lordship kindly see.
Yes. Yes.
Page 15. FIR against so-and-so. I have honor to state that the Assam State Dental Council decided to FIR against so-and-so, 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 residents of so-and-so, so-and-so, Nagaon, so-and-so, phone number so-and-so, obtained registration on 21/9/19 as BDS qualified dental surgeon. Produced all required documents. Subsequently, we have also received a complaint from Otindra Das, care of Joy Durga Medical Jagi Road, Morigaon, who claim that Mohammad Moinul Haq is not a qualified dental surgeon. The council called him to the office and asked him to submit all the documents of his office and asked to produce few more documents by so-and-so, so-and-so, so-and-so. Moinul Haq failed to produce the required documents. Rather, he submitted once again false documents changing the date of internship certificate. The council required whole matter and communicated to the principal of concerned dental college at Kanpur, Uttar Pradesh. The principal of Maharana Pratap Dental College and Hospital Kothim on so-and-so, 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 informed by later dated so-and-so, 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 that Moinul Haq was not even admitted in their college, copy and close. Council was cancel his registration and remove his name from the dentistry registration with immediate effect with white number so-and-so dated 25/3/2021. So in 21, their license was cancelled by the council itself. 25/3/2021. Now, surprisingly, my lord, in the entire petition, Lordship, now the petitioner has claimed that he has a degree from the alternative medicine. In this petition, there's no whisper at all. In the earlier case, though he has come for the quashing of that particular FIR also, and at that time, though now he is claiming that his degree with alternative medicine that was given to him in 2006 itself, as per the annexer, as 21, page 26, as per that certificate, date of issue is 14/9/2026. 2006. If that be so, my lord, if he is
That is a page?
page, my lord, page 26, annexer 1 in this particular petition. Second petition. There is no whisper at all that he is having a degree from Northeast Council of Alternate Medicine, my lord, and he is rather pursuing under that certificate. Page 26 of your petition. Our petition.
Yes.
So now he has come with this new ground that he is having a certificate of or license. But we are not concerned with this, my lord. Our concern is that the degree used by him, BDS, whether he is having a degree of alternative medicine, we don't know. But our case is simple that he is using our degree. He must be having 10 degrees. We are not concerned. But the degree he is using, that is a fake degree. Degree which is used, which is the certificate or the license which shown to be issued by us, that is fake. That is our case. He may be hundreds of degrees. We are not concerned. But we are concerned that the degree you are showing that you are having the BDS from us, that is fake. That is our case. And that has to be determined during the trial, not here. And now this case is already proceeded to the charge. Already witnesses has been started examining. 2 witnesses has already been examined. They have not disclosed all these facts. Now regarding the second FIR, this is not in second FIR because the second FIR, our content, first part is the same, But we are alleging that in spite of the cancellation of so and so, and in spite of the FIR, he's still pursuing the same practice.
New cause of action.
The new cause of action. Because every time he's treating a patient, that will be a new cause of action. Using that our degree. That is our case, and that will be decided by the trial court. Because our case is very specific. The page 30 of my lord, his second petition, page 31, the page 31, the last line, my lord. Yes, we have specific allegation. As per the Dentistry Act, no dentist can practice dentistry without a validation, but the Moinul Haq is practicing dentistry as before. So what is as before means? The earlier.
Yes.
Which is not permitted. So our case is, second case is that as he is pursuing the same, being a quack, he is doing so, my lord. So all the cases he's relied on, it is on the same facts for the same cause of action. But here, it's not the same cause of action. And the place is also different. That was the first one. It was in the Jagi Road. There's an FIR, and this is in Nagaon. In Bhangagar, we have lodge. It was forwarded to the Nagaon. So whatever the TT Antony and the rest of the cases, that is not applicable because it's not the same cause of action. And so this is the disputed, my lord, in the first order, lordship also, the lordship kindly see the order dated 16/2/2022, the earlier disposal order. In that case also, this court is very specific. It's a small order. I'll just read one part, inner page 3/3, my lord. Earlier order,
16/2/22.
my lord.
16/2/22.
Yes, my lord. The inner page 3/3, it appears from the claims and the counterclaims of the respective parties in respect of the document relied upon by, there is a doubt about the genuineness of the document as communicated by the authorities, and aforesaid college contradicts each other on the material facts, particularly as regard to certificate documents furnished to the petitioner. Since this court is sitting over the so-and-so, criminal proceedings not possible to the court to make a roving inquiry in this regard, and so it was dismissed, my lord. And this petition also, lordship will kindly see the IO's reply to the IO's note, later, my lord. He is claiming that he is having the,
Which case?
in second case, my lord, case 52. With reference to the subject cited above, I have honor to furnish the details. Reply number 1, practicing registration is given to those candidate who has complete degree diploma course in alternative medicine from any of the alternative medicine allied colleges institutions subject so and so BDS on Sialda Medical College so and so by Dr. Moinul Haq. Practicing registration has been given. Date of practicing registration provided by the Northeast Council of Alternative Medicine to Dr. Moinul Haq is 14/9/2006. no internship has been provided from Northeast Council of Alternative Medicine as he has not studied BDS of this from this council. So it's also very doubtful, my lord. Appears to be
The
But-
certificate.
certificate. So, my lord, though he is claiming that he is practicing under that, we are not absolutely concerned with that, whether that's valid or not. My case is simple, that we have not issued any certificate is false, BDS certificate. And he is practicing with that particular certificate. That is our. And that has to be proved during the trial. Not a case here. The already and charges already framed on 14/6/5/2022. My. That's all, my.
Lord, I am giving a very short reply. So far, my learned friend is, my lord, doing the case number 52. My lord, here only so far my internship, because if somebody may be pursuing his BDS at Delhi, my lord, he may be registered in Guwahati under the Assam Council, Dental Council. It does not mean that, my lord, I have obtained the degree, but fraudulently on that ground, he is saying that I have not done the internship in Guwahati under this council. So my certificate is doubtful. Where is it stated, my lord?
No, we are not on that question.
Yes, it is. Yes, my lord. Very correct, my lord. Lordship has lightly graved the things. So far the allegation is there, my lord. It is not there. It is not to be decided. But my question is before Lordship is on the same facts, on same ditto, same incident, my lord, whether second case can go or not.
Yes, we have understood.
Yes, and so far, my lord, he said that he already, my lord, cognizance has been taken. In that aspect also, my lord, Supreme Court, in the case of the decision, it has been decided in, my lord, the 25, my lord, the Pradhanya Pranjal Kulkarni versus by the state of Maharashtra, where it is stated, my lord, there is a two power, my lord. It is a one inherent power and another is, my lord, whether this is extraordinary power. So far the 482 is there, my lord. That can be exercised and even at the stage of the, my lord, taking cognizance and the subsequence. But whenever the quashing will be coming under the on the 226, that will be only can be exercised until the search has been filed. After search is filed, matter cognizance is taken, that proceeding cannot be there. So it has been distinguished in this case also, under which circumstances, under which provision, court can go even after the, my lord, taking cognizance. And that case, my lord, in my case, I relied because is after the taking cognizance, I am coming for the quashing. So this is very much distinguished is made in this case. Very clear.
This is
This
Surendra Singh Rathore.
Yes, yes. I have placing this, my lord.
Rathore, my lord, I have also applied. I have also
No,
relied.
no.
And
Paragraph, I am relying on paragraph 9.5, where it is said, where the incident is separate, offences are similar or different.
That's the to scrutinize, my lord. Whether the offense are different, my lord, the incident are different, my lord. Because both the cases are before lordship. I am not done that, lordship. Whenever I understood, my lord, the content of the first case, the same, my lord. Same allegation, some Das has made a complaint. Here also some Das
No,
has
no,
made a
lastly, which citation you are regarding stage at which this causing power can be exercised, that which
Yes,
is
my
that
lord, this
decision?
is I am giving, my lord. I am providing lordship, I will small judgment, my lord. I will take him.
What about the others? Others that you have
Other I
cited?
am giving, my lord, the one copy I will give. Two judgment I will provide. Lordship, and one is, well, TT Anthony, I have already given my lordship. This is, my lord, distinguish is made under the, my lord, whether under inherent power and the, my lord, the extraordinary power, when that can be accessed. And so far, my lord, my learned friend is showing that I have, my lord, on the basis of the fake certificate I am practicing. Kindly see again, lordship, I am giving a trouble to go to page number. This is, my lord, 32. It is starting from 30. This is written to the DGP by the Registrar Dental Council, where lordship will get the page number 32. The main contention of the FIR is this, that I am using the force number of PR 548 But this is, I am validly entitled to use. On the basis of my Annexure 1, that has been license issued by the registration license issued by the Council, Northeastern Council of Alternative Medicine. So that has been not challenged, that has been not questioned by anybody. So that I can use. So if the contention, if it is taken as a toto, so this is cannot be prevail, my lord. Because there is no substantiated document that I have illegally used it. So my humble submission, my lord, the contention is very same. I have gone through the record and we have very much lordship before your lordship. Lordship, my lord, scrutinize the all the whether the contention is same or not. And even the case I relied, the Manju case also, it is saying that during the time of the some, my lord, the minor discrepancy may be there, some another incident may be there, but that to be taken as a whole, my lord. The second one that cannot be survived. So I will provide my lord two judgment when I whatever I relied, my lord. This is Manju case, Manju Chaudhary case, and the another one, my lord. I will provide the copy to.
Yes.
My contention is same, my lord, that he is continuing even after the first FIR. And regarding that the PR number, his own document shows at that time, though we are not concerned, that says that at that time it was not renewed, my lord.
So either way.
Either way, my lord.
No, my lord.
At that time, his
Okay,
own.
we'll examine your contention.
No, my lord, in
His
same things, my lord. I
You
have-
say it is under renewal.
Yes,
Yes,
but
yes,
in this, they specifically admitted that I have filed application for renewal also. Same document, my lord. Last line, my lord.
So at that time, so FIR also, it was indicated that in that BDS also it was not renewed or PR is not valid.
And it is renewal is a lapse, my lord. This cannot say it is invalid, but I am not legally
Yes.
entitled to practice.
So
my
if
lord.
my today's license is not renewed, my lord, can I practice?
They are not on that, my lord. They
So
are on the
my
same-
simple question, my license is given to a particular time in
They are
the,
on the BDS,
if-
my lord.
my lord, in it,
Yes.
whatever, he said there is no renewal. In our case also, without renewal, can I practice, my lord? Till it was not renewed, that's all.
That by the decided by the council concerned who has issued the license to me.
Yes, yes, that will be decided by the trial court, not the high court is not the.
But the second case is not maintainable.
Yes.
I will provide this as.
Devi.
Master.
So item number
Okay.
30, my lord.
Notes.
Lordship may kindly accommodate me for the day, my.
Which
I
one?
missed the brief in chamber.
Item
Item 30
for the day.
for the day. Let the matter come up to,
Tomorrow we don't know.
if it is otherwise possible.
Next week.
Last.
It is available, but
Come to the FIR. Kindly see the informant is Lakshadhar Deka. And there are two accused persons, Harmohan Deka and Sanjoy Deka. Harmohan Deka is the brother of the informant and Sanjoy Deka is the son of the. There is a quarrel regarding land and property between the informant and accused number 1, that is the brother of the informant. They were engaged in a quarrel. The informant expected his son, the petitioner, to take part in the quarrel in favor of his father, but he did not do that. He just disengaged them. Therefore, he is also implicated. This is my instruction, Lord. Otherwise, after the quarrel, the informant got some injuries, was taken to hospital. Now he is taken care in the house by the petitioner, Lord. Their father and son, Lord.
Yes.
in the injury report, Lordship, in the remarks, investigation, it is shown as grievous injury. Grievous injury, Lordship. And moreover, in the statement of the complainant, Lordship, he has stated that this person has not beaten, but in Lordship, conspire in his direction. This brother of the petitioner has beaten Lordship. Lordship may look into it. If
Was he present in the place?
Lordship.
Was he present at the place of occurrence, this petitioner?
Yes, Lordship.
Hmm?
He is also present.
Disengage them. My instruction, disengage
It
the
is there,
informant
it is
and the accused number one. His grievance is that I did not take part in his favor. That is his grievance, Lord. I was there because I disengaged.
Informant is Lakhodhar Deka.
Yes, Lord.
And the accused to is son of Lakhodhar Deka.
Petitioner is the son of the
Another person is the brother of the
informant.
informant.
There are independent witnesses also against.
But I was there. I did not inflicted
They did
any
not say that. They said at your instigation.
instigation is because that is a grievance of the informant that I did not take part in his favor. In my father's favor, I did not.
Informants
Rather,
grievance may be that, but what about the other witnesses?
rather I disengaged them from
Is
quarreling.
what you keep saying, but none of the witnesses support you.
After Lordship, the quarrel, I took my father to the hospital. Thereafter, he was brought to home. Now I am taking care, Lordship. We are in the same house. Either in the aspect that father and son are living in the same house. That I think
Picture of the arm, I think. And third council petition. And it- The government, the father of the petitioner, and petitioner, brother of the accused number one. Application on the day of occurrence, the accused number one, the application of the petitioner attacked the informant. Hit him different parts of the body with sharp weapon, severe injury. Painful. Submitted on the petition. The petitioner had only intervened to separate the accused number one. Train. Carousel of the CD seen that the government has stated the both the accused person. There are other who have stated medical report states one previous injury, that is fracture of the left. While the others injuries fully affected. The allegation assault the oh, allegation it is for available. Cordial invitation. It is in view of the it the is subject to the period of 7 days. Try to immediate influence the witness. So, deeply obliged.
Should be not available.
Not clear order is that please.
But you're on interim.
I know.
When?
Fourth of
Order passed
December.
earlier to continue till the next date of the
Obliged.
But finally, turned the method as my has
Moreover, CD is also not available.
CD not available, list again.
Fourth of December.
a lot longer date.
Day is only 21. In 10 days from Vishwanath Sare.
Bail application. If the background of there's one person, my lord, named Aryan Kumar. He submitted a PRC status certificate. It was procured from Assam. He's a person from Bihar. CISF, he submitted this certificate. Apparently a fake certificate. Now Aryan Kumar engaged one person named Anand to procure this certificate. Anand engaged another person named Pinku.
CD here. Yeah.
Anand engaged my lord Pinku Chauhan. Now, this certificate was issued by one person named Biren Singh Ingi, who was the cowboy. And this petitioner, before your lordship, he had introduced Pinku Chauhan, who was engaged to procure the certificate, to this person, my lord, the Gaubura, Biren Singh Ingi. That is, we are not denying that part, that is admitted. It has also been protected that the money was paid by Pinku Chauhan to Biren Singh Ingi, and that money was paid through me, my lord. That is also something, my lord, we have admitted, my lord. Not there. This Biren Singh Ingi is a Gaupura from my village. Pinku Chauhan resides in the village where my sister is married, and his house is adjacent to my sister. He came to me and got me to introduce him to Biren Singh Ingi. And I'm admitting my part in the whole transaction. But I introduced Pinku Chauhan to Biren, and that this money was paid to me. Now, Biren Singh Ingi was the person who issued the certificate. This was used by Aryan Kumar for submitting into. That is the case. Admit. Perhaps one case that will also reveal the same.
So that is not the case, Madam. The case is that the certificate is fake, my lord.
That is.
That case is the certificate is fake, my lord, and this person, my lord, along with others, my lord, they took 6 lakhs rupees, my lord, to my lord, my lord, certificate.
That part, my lord, we are admitting.
There are materials, my lord, Lordship may peruse the case.
My lord, we are admitting both parts. The fact that this birth certificate was issued by Biren Singh Ingi, because that person is not a resident of Assam. So this PRC certificate has to be a fake certificate. Certificate was issued by Biren Singh Ingi. Pinku Chauhan procured it through me, in the sense that I introduced Pinku Chauhan to Biren Singh Ingi, and money was routed. So that is also admitted. Only thing which I am submitting is that my role in this, because I was neither the issuing authority nor the person who had used. I have played a role in that transaction, my lord. There is some connection, and perhaps the prosecution would also need my cooperation eventually, my lord, to prove this case. And I am more than willing to participate in investigation, assist them in whatever manner they require. Tomorrow, if they require me to become an approver also, I am ready and willing to. I am that chain, my lord, that think if that chain is broken, their case.
There are also other witnesses also examined. One of them.
Yes, all of them have implicated.
I am not denying my part, my lord. And
No,
this
no, your
thing-
part is, it appears that you are the, as we say, dalal.
My lord, lack of a better word, my lord.
Taking money, my lord, I'll say if they have procured, if they furnish the original certificate, my lord, there is no, my lord.
Fake, my lord. But
Certificate is fake, my lord.
This is not just one instance, according to the regular affair. 51 certificates have been seized, and
It's a big record.
you are a part of all that.
well, in fact, that Tinku Chauhan and Vijay Singh Inghi both were arrested and both have been granted bail on the day of production.
That may be for technical reason.
Police beat them up, my lord, for custodial torture. That is another apprehension. With,
We will say that.
my lord, page 2019, my lord.
Regard the Spencer Learned Counsel for the learned additional EP. The gist of the allegation is that territory it is submitted by Learned Counsel for the petition Dulal Chauhan that his role was limited to receiving the amount of rupees 6 lakhs and handing it over to whom?
To Vijay Singh Inghi, my lord, the Gaupur.
To the Gampura.
Our contention is
Vijay
that
Singh
1.5
Inki.
lakh. Our contention is that it was
Sum of 1 point. The Gampura. Beyond that, he had no role to play in the issuance of fake certificates. There are perusal of the seat reveals and incriminating material against the petitioner for which his custodial interrogation may be necessary. Therefore, not a fit case for grant to clear a bail. However, provided that the it is if taken into custody shall not be subjected to torture. Here is bill application, hence rejected. Okay.
deeply observed.
Let's call for-
Is there not received today, my lord? He is on interim.
All right, she did not receive it again on
12.
Worship, can it?
interim order passed.
8/12.
Charge sheet trial for there is
30.
per when
Take on CD. See. Yes, what is the case about?
just for committal
Sarsited case, my lord, he has been shown abscond under Sarsit.
scholarship. The earlier petitioner approached this honorable court. The interim was there. Accordingly, he appeared before this IO lordship. The record that this is later on it has rejected lordship. Earlier petition I have annexed the orders. Now lordship, one was it lordship by the recording. And So matter is section 370. Kindly see the FIR look delegate. Start social constant relation. Was already married, living in their father's house. Or then they have established a relation. They live in the FIR look now charged custodial each and every trial will face trial with any
Ten copiers come, my lord. I have like the 160.
Yes, we have read.
date of appearance was a married, wife of other person. Now she is living with her husband. It was not a
She is a married woman.
married woman. When she was
Married woman, my lord, he left her husband, my lord, and she was residing with her mother, my lord.
for few days she
And this person, my lord, false promise to marry, my lord, he committed the offense.
So there is no forceful.
forced nothing.
My lord, if
As
somebody, my
reflected
lord-
by my
Yes, my lord. Somebody assured to my lord.
members
marry.
and made physical relationship with her with a promise to marry her.
After that, she got pregnant, my lord.
Yes.
This pregnancy was out of her husband. By her. Now she is living with her husband. There is no occurrence. Now, Lordship, you will appear each trial. Here with reasonable court, the matter is will appear. Lord. Trial.
Now what? Child has been delivered.
Child has been delivered. Lord. As per the knowledge of the petitioner, she is with her husband, earlier husband. Child was also Lord, out of her marriage, Lord, not this. Out of the allegation. Trial. Whether is custody is required. Custody. The next the summons also proceeded by the is
Hard learned counsel for the petition. Hard learned additional PP. This is an application to the application for the fire is that paragraph 2. Subsequently, the IO has filed charge sheet. It appears that the victim has also delivered the child. Page 16, paragraph 7. Is submitted on behalf of petition. The victim now, who is a married lady, is now staying with husband, with her child. And is also contended that the child is not that of the petition, but of the husband of alleged victim. Having regard to the fact that despite allegation of rape, the victim was maintaining physical relationship with the accused petitioner for several months thereafter. From purportedly on the promise of marriage. There appears to be, the relationship appears to be sensual in nature. Prima facie appears to be having regard to paragraph earlier bail application, PRS bail application filed on behalf of the petitioner, AB 4723 was rejected by order dated 16/5/23, as the court was of the opinion that the privilege of pre-LS cannot be extended to the petitioner at that stage. Full stop. Subsequently, however, the investigation has been completed. Having referred to the affidavit, makes sense that the prayer bail allowed. $50,000 shall not try to intimidate witness. Witness. Appear at the trial regularly on comment.
Quantitative search is submitted.
Yes.
FIR is at page 8.
Yes, but is the allegation?
Lordship, allegation is I have been making obscene gestures through message, only allegation. Lordship, 2 section is bailable, Lordship. Only 1 section is.
So you appear there. There is no interim also.
No interim.
Call for the TCR then.
Yeah.
Submitted that charge sheet has already submitted by CS number.
Case number, my lord, 221 of 2025, dated 15/11/2020.
Bless.
Lordship. Have filed an regarding.
Hmm?
Kindly photo.
Submitted that listener has affected dusty service. If it in this regard has been filed. Where is that? It is not on record. But the same is not on record. Is the matter again? When? Court.
May please your matter before the IA is filed. Lordship, kindly peruse the order dated 8/9/2025 by the IA. There is 7
Dated 8/9.
8/9/20. If all facts have been stated, that to the prayer.
Yes.
Fact been mentioned of court, that there was certain direction that has not. Your Lordship kindly take up. Really, that is at the criminal revision number 167 of Division Bench judgment starts.
Why is it listed for orders today?
No, because of the IA. We are saying that with that, actually, I'm not going into the whole matter to see this part, your Lordship, because the that insurance amount stated that has matured long back, it's still not been paid to the daughter of the. Kindly see the direction at the page 31 is the judgment of the division bench. Long back, your lordship, judgment was passed. And the operative part, your lordship will find at page 34, the direction. Criminal petition 167. Page 34,
Yes.
that third paragraph. It is therefore directed, your lordship, third paragraph. It is therefore directed that the appellants shall pay a sum of rupees 6,00,000 was the permanent alimony, the respondent, less an amount of rupees which has already history of the court pursuant to the interim order passed by. The appellant shall also bear 50% of the cost of education of minor child, shall also policy by him the name of my daughter, being policy with this sum assured of 5. The appellant shall also continue to pay maintenance allowance minor daughter as directed by the court under section 20. It is, however, made clear that when the appellant at any point of time fails to continue with the policy by paying the required premium, the appellant within 1 month the said failure shall deposit the lump sum amount of rupees 9 lakhs, the name of the minor daughter, in Nationalized Bank having at Guwahati. To ensure compliance with the direction, the appellant shall send a copy of the policy premium payment receipt to the respondent by post days of making deposit. The appellant shall pay the remaining amount of in 5 equal quarterly installment commencing 2014. In case of failure to deposit any of the quarterly installment as aforesaid, would be open to the respondent to file appropriate thing for recovery of the amount at the time. It is further directed that the respondent shall inform the applicant for 15 days of the date fixed by the authority to deposit cost of education child, and the appellant within 1 week thereafter shall make available 50% of, so that she can deposit the entire amount together with the authority of the education. So basically, these are the 3 parts. First part is the, your lordship, permanent element that has been given. We are not on that. Second part is 50% of the education cost to be given year basis on quarterly. There is a default on number 1. That is why I was filed as per the direct division. Then your lordship, the third part was with regard to the insurance. At that time, the insurance policy was. Now it has matured. In the I have given the insurance policy. It is at the last page. You'll find page 82, 80 of the I. It has matured in 28/5/2025, and till date that has not. These are the issues in the I. Page 80, it's the same one. Your lordship will see that this premium maturity amount is there. It has shown that 9 maturity amount 7,88,000 and maturity date is 28/5/2. Till date that has not been paid the daughter as per direction. And with regard to the 50% of the amount, that also have not been paid. And what in between what they have done, and there was a direction by the trial court, pay the amount of a certain amount without informing us. They filed a criminal revision petition in this on court, and that was on the ground that the person now retired. He is retired. Therefore, the amount that was at that point of time was directed 3,50,000. That was reduced to 3 lakh, 1 lakh to pay without interfering the order. Now they are not paying it. This is the issue. Neither the insurance policy, only is they are intermittently paying that monthly amount to the. This is the issue. That is why we are forced to pay the IA, file the IA on the basis of the direction of the honorable court. Already I have mentioned the court has given us the liberty to file appropriate. We are filing, your lordship, nothing is coming. And in fact, your lordship, in the Tribune order, we have annexed in the criminal petition. They have in the criminal petition itself, it was very indicated by the that trial court that the opposite party it appears the opposite party was found to have deliberately absent for which the case hearing in absence of the. So they were deliberately absenting most of the time. Whenever they appear in this court also, either they take adjournment, they don't appear.
So what direction is required to be passed in this? As per the order dated 8/9/25, it says that
8-9 is only to bring on record the other two petitions along with. But my IA is with regard that day the order was not because the other two applications were not along with this. Today my only humble prayer is with regard to because insurance part at least some indication may observe. Rest, your lordship.
no direction is already there. Direction of the division bench is also there.
Yeah, it is there.
So what would a further direction do?
So that-
You have to
it
go
is
for
why it-
execution. You have instituted execution.
Now, that is what your lordship in the division bench order also. For the last part, it has said in case of failure to deposit of any of the installments, then the respondent to file appropriate proceeding. We have proceeded, file the proceeding for
Yes.
execution. That is there. Now the insurance amount has also, your lordship, matured. That is also not paid because there was no
That will
directions
also be
coming.
part of that execution proceeding.
Yes, but no directions are coming. And all these matters are taken one after another, one after another. The other two cases are filed by them. One is challenging the amount which was given to us, and there was an interim order reducing the amount to 50%, and which is being continuing, and they are not appearing. That also not coming to a logical end. Then the other one was filed by them for reduction of the order passed by the executing authority. Now we are stuck without anything here. This is why, since they are not appearing, I am also not forcing upon your lordship. Then this is the reason, your lordship, I am trying to point out at least some observation with regard to the insurance, at least to the directing the executing court. That was the problem. Other two applications filed by them are one for the amount to be reduced, and the second is with regard to the direction filed by the I think that is filed by the executing.
The only way you will be able to realize the money is by coercive measure.
That is also true, but nothing is happening. So I was forced to file an IA so that something comes out of it. Lordship, if the records are not available, obviously, if the records were available, there were so many dates without any, your lordship, orders. And when the order has been passed by the executing court that you pay at least the interim amount of this, that also was stayed. Or that also was challenged before this on. And without even informing us, an order was passed. An amount of 1,50,000 that was paid, we have received. I will not dispute. Now, the insurance policy, whenever I raise that, they are not there. It has matured in May. Now we are in November. At least some amount would have come to the, because the daughter is studying in Bangalore.
What was the direction of the division bench with regard to this amount of insurance
If
policy?
that is there, your lordship will find page 34 of the division page. Page 34. That was at that point of time, the policy was not matured. But considering that, page 34, the third paragraph, lordship will see with regard to the appellant shall also cost of education shall also continue with the insurance policy and by him the name of my daughter in policy number so and so. This is the policy number is with the sum assured of 5 lakh. The appellant shall also continue with the main salary. However, it is made clear that even the appellant at any point of time fails to continue with the policy by paying the required, the appellant within 1 month of such failure shall deposit a lump sum amount of rupees 9 lakh in the name of the minor daughter in the bank branch. So here default pay 9. Now the problem, the default has gone. Now everything gone, the policy is already matured. Now it is being specifically stated, it is in the name of daughter. Pay the amount. He is not. Because she was a minor, it was in his name. Now that is one. These are human issues, Your Lordship. I cannot make a case out of it. Even the petitioner is actually a advocate of the trial court. He does not have a regular income as, so the amount is also required. And he was working, Your Lordship, in the railways. And admittedly, he was earning 1,80,000 salary at that point of time. And these are amounts were secured long back. And it is not that amount he will have to pay from his pocket, from the insurance. Only thing is that there has to be paid to her. Sorry, to the daughter.
All right, heard Mr. by Mannan Learned Counsel for the none appears for the sole respondent. This IA has been filed for passing of necessary orders in connection with criminal execution case number 137/2015 rising out of FC criminal number 6006 pending in the Court of Principal Judge, Family Court number 1, Kamrup. It appears that previously the division bench of this court had directed the respondent
Directed the appellant. They came before.
present respondent
Present.
by order dated 12/2/2015 passed in criminal revision petition 400 of 2013. To continue with the insurance policy taken by him in the name of the minor daughter, being policy number 4854549994. And in the event of his failure to continue with the policy by paying the required premium, he was directed to deposit the lump sum amount of rupees 9 lakhs in the name of the minor daughter. Full stop. By now, the policy has matured. But do you have the date maturing?
Matured date is 28/5/2020.
On 28. But however, the respondent has not deposited the maturity amount in the account of the daughter of the present petitioner. Accordingly, prayer is made for necessary directions in this regard. Having perused the record, the respondent is directed to deposit the maturity amount amounting to
Maturity amount is 7 lakh,
788,000.
7 lakh 88 pays of IA.
Pretty amount of is 788,000 in the bank account of the,
Lakh 88, 7 lakh
yes, in the bank account. Where will he deposit?
the bank account, the child, your lord.
Of the daughter of the petitioner,
That was
namely,
the direction.
what is the name of the daughter?
Just
Tanya
I'll give-
Kashyap.
we give the name. if I-
Tanya Kashyap.
Tanya Kashyap.
Hmm.
Tanya Kashyap, yes. Tanya Kashyap.
But is the bank account detail available with him?
It should be, your lordship.
With the
because
respondent, he has
application-
been paying
applications are
earlier.
There.
Earlier, he was paying some amount.
He was
yes.
paying him. That is why. Or your lordship may also indicate that the petitioner shall furnish bank account details of the
The details
Tanya
of which will be furnished by the petitioner to the respondent. So we dispose of this IA, or should we keep it pending?
the rest amount, that remains.
Also, rest amount is,
That just only that direction. Today, I'm not pressing
Okay.
because they may dispute the other.
release the matter again. On, give a date.
Lordship has directed us if the account
Yeah,
details,
account details.
and then he will pay on.
So
Rest of-
within a period of. So account, money is already with him
His will everything.
in a
This
within a period of 2 weeks from today.
obliged.
Date for filing and file to the record date. Lordship, as per the order, my lordship, order dated 25 my lordship. At para number, their reservation was called, was it file? I will, during, yeah. Other my lordship, the case my lord to peruse page number 245. The exhibit case file.
Yes, what is required now?
My lord paying
No, but service is the respondent
service
here.
provided.
Huh?
Service
Then the order is that it will be considered hereafter.
my lord, there was part of that this then
So this now execution case is filed against you.
my lord, execution case was filed on 9/10/2025. The notice was issued on 10/10.
So what is the impugned order?
My lord, the order. Peruse my lord, page 4. My lord, the relevant portion 37. Petitioners are my lord, the petitioners are the my lord, the my lord, my lord,
Just a moment, we want to see the order.
37, the last part. Para number 20. My lordship, 8,000 was directed to be paid. My lordship, we are the sums. My lordship, the respondent herein is the third wife of our father. Third wife of our father. During the family settlement, my lord, has taken her amount of money which is admitted in her. I have next. Thereafter, my lord, after taking care the property, the money, everything. Thereafter, she has filed a petition. Wife. We are our father is the third wife, and we are the sons of first wife and second. So we were directed to pay.
Ziaur Rahman,
Yes, my lord.
Habibur Rahman, and Mujibur Rahman,
Yes, my lord.
and Faizul.
Yes, petitioner, my lordship petitioners, petitioner, the first wife son are petitioner number 1, 2, and 3, and second wife son is petitioner number 4. This is the third wife. And during family in her care, she has admitted, have also submitted the asset level, everything was. $1,000 each by each respondent, wife, $1,000 by each respondent.
Where is the father?
Father expired, madam. After the death of father, my lord, the mother of petitioner number petitioners are also alive. All the 3 wives are alive. The 1, 2, and 3 are residing along with her mother. Petitioner number 4 is residing along with his mother. Thereafter, my lord, after the family settlement, everything back, the cultivation, the money, and even the house. And thereafter, my lord, and even in the evidence, even the evidence of admitted of taking her share, her property, and even admitted that she's taking the crops of the cultivation along with her every year. Thereafter, this I have basically till then because at that time on that day I was asked whether execution was filed or my lordship, page 27. Take a second. So, has completely admitted that she has taken her share amongst total land, well, was done amongst all. She has taken her part of. She has taken money for her daughters and for construction. She's taking the yearly crop. Yes, admitted that part of. Every year she's, and thereafter, my lord, this, and we all belong to the BPL category. Yeah, also. And all the petitioners have their own minority along with their mother.
Whether mother includes stepmother?
Yes, ma'am.
Yes. So in that case, otherwise you are liable to pay.
Yes, ma'am. But amount, because if every tax, can see,
There are 4 of you,
my lord, there-
and the amount is 8,000.
my lord, there is one, but with regard to the property, with regard to family settlement, with regard to the money and with regard to the house, with every.
These things can be decided finally, but
My lordship,
at this
yes,
stage,
my lord,
what is we doing?
if it is, my lord, if that, then in the learned file को maybe or case okay. So this service and my yes, my lord, with all the evidence record that or in a benefit, then my lord, just every time we then admit that my dear,
At this stage, we do not know she has 2 children, is it not?
yes, my lord.
Then
My lordship, no, my lordship, there was a deposition, I have annexed. Next, I have annexed. all the-
yes, you're saying what?
My lord, with regard to the admission, with regard to the, taking of money, 1,50,000 at that point, taking 3 bighas of land out of the total, because there were, out of which 3 taken, I have on proportion amongst my lord. Just taken a part of that, because the mother, first wife is also alive, second wife is alive. The mothers are alive, they are also just. We have minor children, and 2 of us are only planning. They have, and they're very healthy, healthy,
When was the step taken?
steps. My lordship, immediately, my lordship, the notice was 5 6.
Well, if she has instituted execution proceeding, then we can direct the service of notice to the executing court. No, that is not receipt of the notice of this case.
Yes,
They filed it, then once they appear there, the executing, they can receive it there.
on minus 7 grade. First, below, there, I have made a categorical statement. There. The matter was class of 8. In six 2012.
Okay, you effect dusty service on her on the next date, whatever the date is there. Submit affidavit. If they refuses to accept, then you submit the affidavit accordingly. But it says the Borwa Learned Council for the petition. As per office note. Notice was issued upon the sole respondent by speed post on 23/10/25, as well as to District Magistrate Lakhimpur by speed post the same date. But service report in respect of the said sole respondent is awaited. It is submit. In the meantime, the respondent has initiated execution proceedings. And praise for passing of an interim order. However, this court considers it fit to give an opportunity of hearing to the respondent before passing any interim order. Accordingly, the petitioner is allowed to effect justice service on the respondent on the next date fixed in the execution proceeding. And submit affidavit. Is the matter again on
Court of
court?
My lordship, one who's up, any can of record of can the scan copy of the
Also call for the scan copy of execution records.
my lord, that is why I'm calling for this scan copy of the because the execution case that you one case on
Yes, give the case number.
yes, if it my lordship. Is case number 44/2020 pending for the honorable subject. Yes. Please.
It is a an appeal along with an application of actually what has happened from 24/2022, the accused have been in jail. Now today is 3 years, 7 months. Now he has been convicted for 10 years under an offense of section 4(1) and 376. The offense took place in 2014, 13/1/2014. Or should find the judgment from page 17 in the main appeal. No certificates was produced for determining the age. Hence, the medical opinion said the age is 16 to 17 years. The margin of error should have been given to the accused. However, the same was not given. Now, Lordship would find page 16 is a judgment. From para 24. At page 33, the court considers the aspect of age of the victim. The learned court discusses the law at para 28, page 37 is the opinion. While going to the Azahar, para 28. While going through the Azahar laws by the complainant victim, she mentioned her age as 14 years. While the victim adduced a statement before the judicial magistrate, she mentioned her age as 14 years. PW2, the mother of the victim, in her evidence also deposed at the relevant time of incident, her daughter was studying class 9 at so-and-so high school, and the age of her daughter is 14 years at that time. Although the investigation should have collect the school certificate of the victim, in which she
was reading at the relevant time of incident, but he failed to collect any documents from the school authority pertaining to the determination of age. In absence of documents pertaining to the age of the victim, the evidence adduced by the medical officer is relevant. And while examining the victim on the basis of radiological report, medical officer hold that the victim at the relevant time of the incident was 16 to 17 years of age. Although the victim and her mother had deposed that at the relevant time victim was 14 years, but none of them could produce any birth certificate and depose a exact date of birth. Moreover, the defense also have failed to rebut the evidence of the prosecution witness regarding the age of the victim during the cross-examination. Hence, considering all aspects, therefore the victim at the relevant time of the incident was above 16 years, hence is a minor, therefore falls within the purview of 2D. Now, Lordship, the age was proved only by the radiological report. Lordship, there is a catena of judgments which says that the margin of error of 2 years should have been given to the accused. That is my first point. Secondly, Lordship, the entire incident was proof on the sole testimony of the victim. However, there are contradictions with the medical report also, the IO also, and the other witnesses. Lordship, today, Lordship, I will pray that since the accused has already spent 3 years, 7 years in jail, 8 months in jail, and the sentence is 10 years, Lordship, Lordship may consider the bail application. Lordship, at page 15, Lordship, the medical judgment. Para 18, Lordship, would find the medical report also. It is the radiological report that is in the judgment, and at page 129 is the medical report. The offense was alleged to be committed on 13/1/2014, but reported on 17/1. Now, Lordship would see at para 18. In her cross-examination, she deposed that on 17/1 at the relevant point of time of the victim girls, she was not in her duty. She has not seen the X-ray report before the court on that. She further deposed that freshly ruptured means was done within a period of 24 hours. Therefore, Lordship, the offense was committed on 13/1 and reported on 17/1. Therefore, and the delay is not explained in the FIR. The victim says that the delay was caused for the from the village meetings that was conducted on 3 days. Now the IO in his statement says that there is no proceedings of any meeting that was held on these 3 days. There are other contradictions with the other witnesses also. But what I wanted to submit that even the sole testimony of the victim is not of sterling quality. The statement of the victim, Lordship would find at page 114A.
Yes. Prosecution.
I couldn't do properly. Still, in order to bring home the guilt of the accused person, in the so one of the section of box state, she prosecutor has examined 6 witnesses. The met- the met- given. PW1, may I read the deposition?
I have seen the
Yes.
deposition
Uh,
as
PW5
reflected in the judgment.
Yeah, wife who happens to be the star witness. She has categorically in her depositions stated that she has been forcefully sexually assaulted by the present. But as her statement is concerned, also corroborated the state medical examination, which is PW. PW6 lordship. Hymen is freshly ruptured. Since she has been examined on 17. She was examined on 17/1/2014, and date of occurrence is on 13/1.
What is the medical finding?
17/1/2000.
Yes, what is the finding? Finding?
Finding is hymen is freshly ruptured.
Huh?
Hymen is freshly ruptured.
Freshly wrapped. It is supported by the medical evidence also.
Lordship. PW5 happened to be the victim. Deposed in her evidence, Lordship will find at page 24. That the incident took place on 13/1/2014 at about 7:38 p.m. evening. On that day, due to Ruka festival, he went to the residence of her uncle nearby, distributing fish. On her way to the residence of her uncle, she met the accused person. Although she called her, she refused to near to ask if he has to pay. Thereafter, the accused person near to her, gagged her mouth by his muffler, and at that moment became senseless. PW5 further deposed to regain her sense in a paddy field near a Shiva temple. At that moment, she saw the person holding her hand. And after regaining her sense, she realized that she was raped by the accused person, and she asked him to why he committed rape upon her. Then he told him to worry about that, asked her to go. He also went. He came to her residence crying. She narrated the incident to her parents and uncle. Thereafter, her cousin brother, Krishna Karan Karat Kolita, went to the residence of the accused person, inquired whereabouts of the accused person. But the father of the accused person told that he was present, although he was hiding. Then her family member, Trogao, calls. Although 3 members of village was held, different occasion, the accused person and the family member failed to appear on a single occasion. Due to failure of the accused person and his family member, the village asked them to take the help of law. Accordingly, she has lost against the accused person and exhibited, FR is exhibited as Exhibit 1 and Exhibit 1 signature. After lodging the Azahar before the police, person produced her for medical examination. In her cross-examination, she deposed that while she went to lodge the Azahar, cousin brother, her sister-in-law, Amaya Kolta and father Uttam Kolta. It takes half an hour to reach Deposit arrest. The father deposed in her cross-examination that the incident took place on 13/1. it lost Jahar on 17/1. She clarified that due to calling of 3 days, delay was caused. So the plea that my friend has taken that was lost delay in causing lodging the FIR because sufficient ample reasons has been given because on 3 occasions today's meeting was held, 3 occasions he has failed to come to the Bicharman. The defense side on length put suggestion victim to he has denied. He further deposed in her cross-examination was seasonally bearing a from she wears relevant. 5 for the deposit cross-examination that in that village written resolution taken as of state 2014 and all 3 meetings although 3 are Burhal represent deposit cross-examination that the distance between the places break first initially act her his the lordship in her cross-examination the vital point as regard to the minority of the age of the victim was put by the defense in her cross-examination regarding her age was find that relevant. Cannot state. Moreover, PW6, who happens to be the doctor, also medical evidence says the hymen breast ruptured. That is also corroborated, and risk attend does the injury is required. Case of death. Then this PW7 is the investigating officer, who is posing for evidence that Pensko was working off. On perusal of the case that earlier test has been written as part of the scene. Before the repose in his evidence that perusal of the reveals that later on, 10/7/2015, the aforesaid case was he took the charge of investigation of the instance case being profit after the scene. He found that the accused person yes. On the same day, he went to the place of occurrence, viewed the sketch. Example. And lordship thereafter he has filed search sheet. Section 76. Debated the search sheet. Visiting of occurrence, the state medical exam also done. The victim before the judicial magistrate, recording her state. Recorded. State. So. Lordship, prosecutor's statement is found to be trustworthy. Good corroboration required. Although it here in our present case, corroborated as well as the medical, as well as the medical evidence. To that regard, also I some the learned court below has rightly convicted the accused under section 401 of section also of lordship. I'd like to state the Justice of State of Punjab versus other 6 cases create in case of no injury mark is required. Air 2025 is 7.3, Deepak Kumar State. Para 5. In case of 376 IPC, no there is required. Contradiction, sir. Minor contradiction.
Okay, we
Does not-
cannot go to that depth anyway. We are examining the IA.
Yes,
We have to pronounce on those aspects, then we might as well decide the criminal appeal. Right. Yes, anything else to submit?
Yes, regarding that medical opinion, Lordship would find it para 18, Lordship. Para 18, that is my point. That at page 28, in her cross-examination, it was asked for what is mean by freshly ruptured.
Yes, we have noted that.
Yes. And moreover, at page para 19, page 29 is the statement of the IO. IO in the last part, he further deposed in his evidence that on perusal it reveals that the page 30 last part. He
Page 30.
admitted, last line, admitted in his cross-examination that the earlier investigator has not seized any written proceedings of village meeting of the incident case. Therefore, what was said to be a village meeting in the statement is not correct. And secondly, since 4 days delay was there, the medical opinion is also not collaborative because the freshly ruptured part has been clarified. Now, Lordship, I will place one judgment. There are many judgments. I will place one judgment regarding the margin of para 26 onward. It's a criminal appeal J24 of 2020. Jail 24 oblique 2020.
Okay, we'll see that.
It discusses the
All this
entire
is
law.
Sort of settled law.
Settled law. It is para 33. It is well settled that officer or medical test through its guiding factor for determining, but this and leaves a margin of error of 2 years on either side. This settled position that benefit of doubt with regard to the age of the victim always go in favor of the accused. In the instant case, the radiological has assessed the age to be 16 to 17 years. Considering the margin of error in age even as 1 year, the victim would be 18 years of age and would not be a child within the meaning of 2D. Same here. There
Even then, you cannot escape from 376.
For 376, I am pointing out the contradictions regarding the medical opinion also in the cross-examination of the IO also. There is a 4 days delay which is explained later, not in the FIR, and which has been contradicted by the IO that there is no meetings.
What written record will be there in a village meeting? Will gather.
No,
they will turn up.
They say that there are written records. Firstly,
Who say?
the father of the PW1 says the father PW1 85 page.
That's what did he say? Village proceedings were in written form.
Yes, it was in written form. There's 87 also. Written resolution page 87. The third line. PW1. Written resolution had taken in the public meeting and written document had given to the victim's father. Page 87. cross-examination of PW1. Approx 30 to 40 numbers of people were present in the meeting. Lordship, now while considering this aspect also, Lordship, now the girl has been married, Lordship, there is no disturbances from the accused person or anybody else, Lordship, before his imprisonment also, Lordship. Therefore, Lordship will consider this aspect also.
Is that to be considered? Why she has to remain unmarried?
No, you see,
Of course, she has got married. What is the difficulty?
yes, Lordship, that is, now she is leading a normal life without any scars of this, Lordship. That what I is pointing out.
Yes, you are appearing.
What I wanted to submit is that if it is a sole testimony of the victim, it has to be of a sterling quality. But here though there are some contradictions, Lord, therefore, her statements are not of sterling quality, exceptional trustworthiness. That is my is regarding 376. Deeply.
If I'm appearing for respondent 2, as the case is listed for hearing, my lord, these submissions that can be disposed of rapidly, I will submit. Firstly, my lord, one thing, one vital.
No, we are hearing his submission is on the understanding that we are hearing the IA, not, he hasn't taken us through the, he has not taken us through the.
In any way, my lord, one thing I would like to point out, in one of the ground, IA as well as Hill, my lord, he is on terms of punishment. Earlier it was 7 years when the occurrence was taken place, but conviction is after amendment was given as per new act, 10 years. So that is one of the vital point. Lordship. Otherwise, I am supporting the argument of case of IA. On that point, I would like to agree.
That was the point also taken in my grounds that on 2014, the occurrence
Punishment was 7.
took place.
So
It
at
was
least,
7 years.
at least to that extent, it was to be,
Yes.
it will definitely entail interference.
Fine.
Yes.
And once it is 7 years, and it is for a fixed period, and petitioner has undergone almost half of it.
More than half, 3 years, 8 months.
Years, 8 months.
If
That was the
lordship
first thing that
decide-
would have been pointed out.
If lordship decides
Instead
to
of-
appoint my lord, then entire appeal would have been instead of giving interim bail at this stage.
No, how
That
could it
is
be
the ground I
disposed?
have taken, first ground I have taken in my appeal.
We could have still maintained the conviction and modified the punishment.
My lord.
How can you say that the appeal would be disposed of on that ground alone?
No, my lord, that is one of the vital point I am pointing. I would like to address on that lordship
Yes,
intending to dispose of, otherwise at the time of hearing, I will address.
yes. We'll pass orders on the IA first. Huh? Yes, we'll decide the IA. Yes,
Lordship,
for
I have-
delivery of order.
Section 44.
I've
was
also
very much-
annexed the pre-amended POCSO Act at page 117. 117, Lordship, whoever commits predatory sexual assault shall be punished with imprisonment, either description for a term shall not be less than 7 years. That page from 116, I have annexed it, annexed the entire.
No, this is under POCSO Act. So if not less than 7 years, that means 10 years is permissible.
Yes, section 42 of POCSO Act Lordship altered is greater. That has to be taken.
In fact, 4-1 had not come into existence when the offense was committed. 4-1 has come in 2019.
If it is 76, then greater punishment will be greater. It is 10 years.
2014?
Lordship,
2014,
yes, date of,
what was the punishment?
that was 7 years.
Yes. So it's 376, that would be 7 years.
376, 10 years.
No, at that point of time.
Less than 10 years. That which makes
will-
them,
Are you having the old act?
yes, Lordship,
Pre-amended act?
yes. 2013. 2013,
13.
yes.
Then
By Act 13 of 2013, Section 9.
with effect from
Which effect from 3 to 2013.
an occurrences of
Lordship,
occurrences of which date?
2014, 2004.
Then with 10 years here also.
Then
13-1. 13-1 to 2014.
effects from the 25 to 2020, 2013.
Lordship, for only for the purpose of bail today, Lordship, I am saying that I have already spent 3 years, 8 months, Lordship. I have already seen, shown that, Lordship, there is a glaring error in calculation of the age also. The margin of error has not been taken. There are contradictions.
So to that regard, defense has not taken any, has they put any suggestion to the prosecution witnesses, Lord?
And
So this
there are
he cannot take it at
contradictions.
this time, at this stage, cannot be taken.
In the testimony of the sole witness. Deeply.
Yes.
Delivery of order.
Deeply obliged. There are
Is your matter has otherwise hearing, but the IA is also pending.
Is the IA?
Inclined to have the IA for suspension. The case method, initially the appellant was charged under section 6 of the IPC along with 376 of the IPC. Subsequently, during trial method, he was acquitted of the offense under 66 and convicted under 6, sentenced to undergo 10 years. I'll just give a brief background. Initially, this FIR was lodged, alleging that the appellant, along with one Deposit Sharma, they took the victim, another friend of her, to an under construction house of Quick. They kidnapped victim along with her friend were kidnapped, abducted, and taken to the house, and therein they were raped. Now, during trial, the learned trial court came to a finding that this allegation of abduction is absolutely baseless because the victim, along with the girl, had voluntarily informed the appellant, and after the act of sexual intercourse, they again voluntarily left with this the appellant. So this allegation. Secondly, my lord, this other friend who accompanied him to the under construction house, he also came in evidence very clearly that they had voluntarily gone there. They knew each other from beforehand. When they went inside the room, both of them, the appellant at the hour they came out. Then the appellant had said that, and then thereafter, both the got into the car and have the place of occurrence. In fact, there was some part of the it was the environment. These category friend of the victim. Our has been consistent. The trial did not deny the fact of the sexual intercourse. Admitted on that day we went there. There was sexual intercourse with the victim, but it was a consent. The victim says that she was forcibly raped, but the victim also says that she was forcibly abducted. That part was found to be false. One part of, major part of her case found to be false. Then the question to the Lord will examine is whether she traveling with. Because that is one part. And the eyewitness of the very incident, then who was there all along, he also deposes to that effect. So in that case, whether her testimony remains blemish-free, the testimony. Apart from that also, my lord, but that is something the Lordship will examine in the hearing. All the allegations regarding force, intercourse, and the accused are inside the. Then in fact, there is also an allegation. The act. There are major contradictions to the previous statement. All of those. I'll take your Lordship. The judgment, your Lordship will kindly come to page 21
Of the appeal.
of the IA, my lord. It's Lord,
Yes.
the first paragraph, matter the allegation. Prosecution is unfolded on trial in 40 fire for the case against Nidhu Sharma, this is the appellant matter, and Devajit Sharma, inter alia alleging that on Suren's date at 6:30 p.m., daughter of the informant, ex aged 27, had gone to Kwalkuti market, and at that time they were kidnapped by the FIR named accused in a four-wheeler vehicle. And accused number 1, Hitul Sharma, with the assistance of the accused number 2, committed rape upon his daughter. Thereafter left her at Kwalkuti Bhagyasri Road in an. This is the allegation. Now your Lordship will come straight away to her evidence. That your Lordship will find at page 28. Starts from the third paragraph. The Lordship will find PW1 in bold. PW1 Lordship. PW1 prosecutor is deposed during her evidence before the court on 7th. Informant is her father and she knows the accused. She deposed that her age is 7 years. And on 21/3/24, her neighbor came to her house and asked her to accompany her to Swalkuti Bazaar at about 6:30 p.m. in the evening to purchase a recharge voucher, and she accompanied, and they went in the direction of the road. She deposed that the card shop was at a little distance from Bhavan. At that time, the accused persons came in an Eon vehicle, stopped near them, and then she said that she will the house of the accused. Deposit, and she boarded the vehicle and also made her board that vehicle. And that time she could recognize both the accused who were in the vehicle. She further deposed that accordingly they went in the vehicle to the under deposit. And at that time it was evening. She further deposed that from there they were supposed to return home. However, at that time the deposit pulled her by the hand and took her inside that under constructed house and handed her over to the Hitul, who closed the door and forcefully committed sexual intercourse in that house. She further deposed that she had tried to raise screams, but the accused had gagged her mouth and the committed forceful sexual intercourse upon her. And during that he touched her breast and then he intelligent. She further deposed that while the accused Nitu was committed forceful sexual intercourse upon her, the accused deposit and her friend was outside the under constructed house and they did not help. She further deposed upon committing intercourse there was the dirty clothes smeared with and sand to wipe the. Since she was having a lot of bleeding, she wiped her bleeding. And she got very tired. She further deposed after staying there for some he will show her to doctor for her. Along with and deposit her in that Eon vehicle was Swalkuti medical, and upon recall, accused Nipul went and brought some tablets and he gave her one such, and she took it without reading the label as she wanted properly. She further deposed after the incident while coming from the under constructed house. She did not raise any screams or even as her physical condition. The way she had come in the vehicles. She further deposed that thereafter the accused person brought them in that vehicle in front of Saraswati, stopped them there and asked her to come to the house. As she had told her, she had more medical. That time she was very weak. But in the interest of stopping her house, after reaching the house, she sat on a bed in their house
Putuli gave her one tablet. Her bleeding increased and her clothes and mattress. She further deposed at the time of boarding the vehicle after the incident, her clothes were their other clothes once safely for the left her previous her blood thin, and then she went to the toilet and she further reported and she told me that if she had not accompanied her, the incident she is also involved. And after hearing this, the elder sister Matu also snatched the goods and she was with. She further reported after 10 p.m. came to drop her home, and at that time she was wearing the clothes they had given. They did not give her in clothes. She reported after reaching her home, she informed and narrated about the and on 20th, her father. She reported the night of when her father had gone to the police. It was quite late at night. He returned back. Police had come to their house, and thereafter on the same day in the father lodged the instant case against the accused. He also accompanied father. She further deposed the police. Ordered, and on 22, the police had taken her for medical exam. That was all. Further deposited James she exhibited her medical report. She deposed she does not know that the police that she was wearing and which were kept house of. She further her to exhibited her state. During cross, she for 10 days prior to the incident, Putuli had introduced the accused and introduced the accused. She further stated that on the day of the incident, what was the mother. Only Putuli was her, and she further was taken on the day. She stated that she knew the accused deposit about 10 days prior to the incident. After being introduced to her, when she had said that they will see the under constructed house inside, then she accompanied her voluntarily. She denied that she had voluntarily gone inside the under constructed had not forcefully taken her inside the under. She denied that after taking her inside the under constructed house had not handed her over to the accused. She denied that Matu, the elder sister of Putuli, had slapped her as because she had gone to their house to commit. She denied that she narrated about the incident to her parents of fear that the elder sister, Matu, the elder sister, of Putuli, tell her parents about the incident. She denied that she did not state before the police that Putuli came to her house on the day of the incident. And she denied that she did not state before the police and in her statement before them that Putuli said that she will go see the under constructed house of the accused. And she boarded the vehicle and also made her board that vehicle. She stated that she does not remember as to whether she stated before the police and in her statement before the magistrate that at that time Devojit pulled her by the hand and took her inside that under constructed house and handed her over to the accused. This was the first allegation that Devojit had forcefully taken her and handed her to. She does not remember. And she denied that she did not state with the police in her statement before the magistrate and her statement before the magistrate that after committing intercourse, there was bleeding from her vagina and that the accused Nitul bought a dirty cloth smeared with cement and sand, wiped the bleeding of her genitals, and she was having a lot of bleeding. Dirty cloth. She stated that while the accused Nitul was committing rape upon her, he had gagged her. He raped her for about. She admitted that she did not state before the magistrate and in her statement that while committing for some she stated that from Saraswati Bhavan to Putuli's house, it would be about 100 meters. She stated that while walking the distance, she had not raised any hue and cry, nor had she told about the incident. She admitted that she did not state before the and in her statement before the magistrate that in their house, Putuli gave her knee under her other for that and left her previous and then she went to the toilet. She admitted that she did not state before the police in and in her statement with the man. Then she told Putuli that if she had not accompanied her, the incident would, and that she told her that she She admitted that she stated that after hearing this, Matu also snatched the. She had told if she had gone to buy the recharge card, the incident would, as she had not asked. In fact, my lord, this all other subsequent developments, these were all suggestions for my. Some she has admitted, some she has denied. All of these have been confirmed by IO, my lord. These were stated. Your lordship will kindly come to page 35, the evidence of para 9. This gives a different dimension to our claim. Page para 9.
No, before that,
No.
if as you say it was a consensual
My lord.
affair, why did she report it immediately to her father and the very next day the Ejaar was
My
lodged?
lord, that is because when that incident happened, because in fact she has also pointed to her process that incident, my, she was taken to the house of Putuli. And then this incident, my lord, was highlighted, and this became known that there was a sexual relation between children and the victim, my lord. Because after this incident, she did not go directly to her home, the house of Putuli. And then her parents would find out such an incident had happened. That in that, at that
Because of the bleeding.
yes, my lord. Then she has no reports but to say, because she could not admit with her parents that there was a voluntary and the appellant. So then this deposit gets imputed because the trial finds that this allegation of forcibly taking her and is false. When one part of the statement, then she will just examine the evidence. PW3. W3 deposed that she knows and also knows the accused the incident took place. She stated that on that day, since morning, the prosecutrix asked her to accompany her to meet it. While she says that it was Putuli who take her, she said that since morning, prosecutor asked her to accompany her to meet accused Nitu Sharma. In the evening at about 6 p.m., he accompanied her to meet said Nitu. She stated that initially she was not keen to go, as the prosecutrix insisted. She agreed to accompany her. As the prosecutor, she agreed to accompany, and then they started being on a tracker. She stated that the prosecutor paid the fare for her ticket in the tracker. During the journey in the tracker, the prosecutrix was talking on the phone from time to time. She stated that she was told that the park was closed, and thereafter she took her to a half-constructed house belonging to accused deposit, and they waited there for about 5 minutes. Thereupon, accused deposit Sharma arrived there on their bike. She stated that the prosecutor, her, Nitul Sharma, thereafter for about 2 minutes, all four of them were together. Thereafter, Nitul Sharma took the prosecutor aside for some talk, and Debojit Sharma, she deposed that Debojit Sharma scolded her as to why she has come, but also told her that without her the prosecutor have been able. Debojit further told her that Nitul Sharma wanted the property. Thereafter, Nitul told her about the park and subsequently the said half. She deposed that there are 3 rooms in the half-constructed building meant for rent, and Nitul Sharma and the prosecutor went to one of those rooms saying that they will talk. While Debojit Sharma was talking to her, she received a phone call that his sister had a scooter accident. She deposed that the accused Debojit present at that for about 10-15. She deposed that after about 40 to 45 minutes, both Nitul and prosecutor came out of the room. She deposed that thereupon she saw that the prosecutor was having, and she became nervous and sat down crying. Thereupon Nitul Sharma told her and said, asked her not to get scared, and said that Kibata Bhut. She deposed that though she was nervous, she could see the prosecutors with the help of Sharma had taken some caution with some closet. And Nitul asked the prosecutor as to whether she would be able, whether she has to. She deposed that Nitul brought his vehicle and asked them to sit in the vehicle, saying drop them. And they boarded in that vehicle, and on the way there was a pharmacy near Swalkusti Chowk. Nitul brought medicine, and he gave her medicine and asked her to take the, also asked to take the remaining eggs. They got down, and from there they walking to her house. She deposed that the prosecutor stayed in their house for 1 hour, and she was in a lot of tension and heavy. She deposed that the prosecutor borrowed some chains and put her earlier to the polythene bag. Thereafter, taking the polythene, she went to her house. And on the next day, police had come to their house. She reported was also taken to the during her and her statement was recorded by the during cross, she stated that prior to the incident, the process the they used to talk on telephone, text, the date of the incident, the process, half constructed house voluntary. So this is also the process. My lord, the version which has been this, my lord, is diametrically opposite. At the end of the day, my lord, for convicting the appellant, the burden of the state is to establish his guilt beyond all reason. The basis of this the version, I witness. In my respect to submit the prosecution, does that burden of or not? In fact, your lordship will see page 45, my lord. Because the principle is otherwise there, my lord. The whole testimony of the prosecutor can warrant the conviction. Then there is a caveat to it that my has chemistry and of studying. Here a prosecution itself was present there is giving a very different word that happened. Page 45, my lord, will kindly come at paragraph 22. Lordship has let us examine whether prosecution the charge and while carefully analyzing the test, the PW, it is found that the prosecutor has one deposed that her neighbor fully came to her home and asked her to accompany in order to purchase recharge and prosecutor is and that I will not keep my repetition. The lordship will kindly come para 24. But while analyzing the above evidence, they found the testimony of the prosecutor, how they arrived at the place of occurrence, is not corroborated by PW3 who accompanied. Moreover, PW1 prosecutor admitted that she accompanied PW3 voluntarily to see the under constructed house. Apart from the above, the IO PW7 prosecutor from the PW1 had crossed 161 state had not stated her home on the day of the incident. Her with the under constructed houses. Careful analysis of the above evidence reflects no sufficient proof that on the day of occurrence abducted the person. So on that aspect, my lord, on a trial court. So now, my lord, whether the other part of the testimony in isolation can be examined, come up with a finding that rape has been committed and that prosecution has been able to fit beyond all reasonable. And one more aspect, my lord, will kindly see. Because sexual intercourse is admitted, that is not in denial, my lord. Paragraph 42, my lord, page 53. Page 54, my lord, paragraph 43. The learned trial court has decided the issue of consent by relying on the judgment of Vipul Medhi. What is consent and what is submission? In paragraph 43, my lord, page 50. Para 27 of Vipul Medhi's case, the Honorable Guwahati High Court observed as however subtle may be, there is indeed form and fine submission. Every consent involves a submission consent. And the mere fact that a woman had submitted to the promise of the accused that her consent existed, unless the evidence of the sexual act which the prosecutor carried out was accompanied by deliberation after the mind had weighed as in a balance, the good and evil on each side, with the existing capacity and power, withdraw the assent according. This judgment, the lordship is perhaps aware of this. This judgment was delivered in the context of a case where there was a false allegation of false promise of marriage. So herein, my lord, the consent, I have a copy of the judgment. Consent was held to have been vacated because a consent was given
on the basis of a deception matter. This is a case where the prosecution has not come with the allegation there was a false promise. Prosecution's allegation was that case of so the ratio of this judgment not have been to come up with a finding that though the victim had otherwise gone, this was not an act of consent, maybe an act of.
So that was the reasoning,
Kind of.
basically.
This is the
This,
reason.
this negates the idea of actual physical forcible rape.
Fine.
If it is on a misconception of fact,
Yes.
then there is no question of forcible
Forcible, yes.
intercourse.
So
But their
this-
allegation throughout has been forcible
Forcible.
intercourse.
So this judgment or this finding, my lord, is not based on this finding, because the next judgment is Gurmeet Singh, but that is settled law, man. So paragraph 5 is the finding, paragraph 45 will. In the case in our hand, the prosecutor is entering into the room of the under construction house with the accused does not indicate that he had consented for sexual. More particularly when there is evidence of struggle and medical evidence.
What is the evidence of struggle and injury?
Injury, my lord. That I will come, your lordship, kindly come. Paragraph, page 41, man. PW 9. And relevant portion, your lordship, find page 42, second paragraph.
Yes.
On genital examination, organs are developed, vulva, a minor and hymen old tear is seen at 1 o'clock. On vagina, redness with blood seen around the petrous. On cervix, blood seen around the cervix. Evidence of venereal disease. In injury on the body. Contusion, reddish in brown was present over the left. Abrasion, reddish in brown in color, present over the anterior surface of right knee. Contusion, bluish in color over left knee. Abrasion below left knee. Injuries were found in the knee. My spectrum of sexual intercourse there, not bleeding, my lord, not this. The victim at that point of that is not it. Only thing is these injuries. Your lordship will also examine the fact that this happened in an under constructed house. The secluded under constructed house which they had gone for having. So the injuries were found basically on her knee. Another thing is found with her. A condom was also used. Overwhelmingly, if your lordship balance, the possibility of consensual sexual cannot be ruled out. At best, I may submit my is the prosecution's burden being forceful sexual intercourse. This cannot be said. That is my response.
Here, firstly, I want to state your lordship.
So we have basically heard the appeal. Is it not?
I want to point out few things, lordship. Here in PW1, my learned friend has already stated what I stated. He has clearly stated that it is forceful, lordship. Moreover, two things are there, lordship. In the, I was having the records, lordship, because I don't have the evidence part. So I'm reading from it, lordship. In that part, after she has been bleeding, she has stated few lines, lordship. May I read, lordship? After staying there for some time, I am reading after the bleeding occurs. After staying there for some time, accused Nitul assured me that he will show me to the doctor for my bleeding, and then he, along with Putuli and Devajit, took me in that yon vehicle towards Swalkushi Medical. Upon reaching Swalkushi Medical, the accused Nitul went and brought some tablets, and Putuli gave me one such tablet, and I took it without reading the label, as I wanted to stop my bleeding. After the incident, while coming from the under constructed house to the Swalkushi Medical, I had not raised any scream or hue and cry, as my physical condition was not very bad, and on the way I had come in the vehicle sleeping.
he has spoken, he has said about the hue and cry lordship. That means he has not consented. Otherwise, he has not been stating about that. Not raised. He want to, but because of her bad condition.
That
bad
has
health-
always been, that
No,
has all along been her story in the evidence that it
is-
was not
Yes,
consensual.
yes, Lord.
It was
There is
possible.
point. That is why I'm taking out. I'm come to the main point at last, Lord. It is there,
Icing on the cake.
Lordship. And on the medical report, Lordship, Lordship has already seen there are contusions, all the about the injury part. One thing is again is there. A gamusa for detection of spermatozoa and any other pain properly signed and sealed, labeled and packed was handed over to escorting police to be taken to DFSL and Kahilipara. And their report is also there. According to that report, Lordship, 2 pieces of multicolored flower condensation show and result is give positive test for semen. It gives positive test for semen.
Which
One gamusa, Lordship, and where it is stated that, Lordship, in the medical report also, Lordship.
how does that prove the presence or absence of force? The
No, Lordship,
intercourse is admitted.
No, it is on vaginal redness with blood coats in, Lordship. These things are there and semen is also there. Moreover, in MR report also
So
there
this
is.
could,
Yes.
these things can be present even in case of consensual.
No, Lordship, it has point. I am pointing out because in new act and in older act of evidence act, there's something, Lordship. In a prosecution for rape under section 2 of section 64 of basis 376 now, where sexual intercourse by the accused is proved. He has already stated that sexual intercourse has been proved. And the question is whether it was without the consent of the woman alleged to have been raped. And such woman states in her evidence before the court that she did not consent. As she has done this in this case, the court shall presume that she did not consent. That means, Lordship, she has not consented. It is in the act, Lordship. It is in the act.
This is not a POXO case.
No,
He's
Lordship, this is
referring to 114.
114A. And in present case, Lordship, 120, a new act. So, if it is proved that sexual intercourse has been proved, where sexual intercourse by the accused is proved, and the question he is raising is whether it was without the consent of the woman alleged to have been raped. So consent is the main thing, Lordship. And in the act is clearly stated in 114A, in the old act, and in the new act, it is 120. So what learned trial court has done wrong, Lordship? It is in the act. He has to presume that consent is not there. Lordship may look into it. It is clearly written in the act itself. Lordship, got it, Lordship?
Yes.
Then, Lordship, it is clearly stated here. It has to be presumed, Lordship. That is why I am stating that in the evidence she has not stated for one at any stage. He has not denied that he has consented, Lordship. He has not stated he has given her consent. And I am focusing on that point, Lordship, because he has not raised hue and cry, because he don't want. If she has given her consent, why she will state that she is in a bad condition? That is why she has not created a hue and cry. And in her 164 statement also, I have seen, Lordship, she is consistent that she has not given consent. She may be good there. I have not on that point, Lordship. She may have love relation. That is a different thing. She has go with her will. That is also a different thing. In regarding to consent, it is in the act, Lordship, 114A. She has not consented. And cement is also present, Lordship. So sexual intercourse has been proved.
Page 40 of para regarding the special finding of the learner. So it is otherwise not relevant. because we are not denying the fact of intercourse. There, paragraph 40. Paragraph 40 of the judgment. In this regard, we have taken into consideration the position of the IO PW7, and as per the evidence of the IO, he has not seized any gamusa or 2 pieces of flowery cloth, as well as any dirty clothes made with cement and sand. As such, that pieces of flowery clothes which was sent to the FSL, examined by PW10, cannot be connected to this. Moreover, as per PW9, he has sent 1 gamusa, not 2 pieces of flower, for example, to police. As such, the evidence of the PW10 FSL report expert is of no use. That was it. No, my learned friend is correct on 114A. Perhaps what my learned friend has confused, presumption with proof. Presumption is always there. Your lordship knows it, 114 is there. But that
Rebuttable presumption.
rebuttable presumption. Now, in this case, the eagerness and zeal with learned friend has argued, perhaps the prosecution should have also shown the same eagerness when PW3 was examined and have PW3 declared hostile and cross-examine PW3. The prosecution comes with 2 sets of evidence. PW1 has said this and PW3 said this. Neither of they are not compatible with each other. Now the prosecution here cannot insist that we are only going with the evidence of PW1 and very conveniently ignore the evidence of PW3. These are both their witnesses, their evidence. And what my learned friend says about consistency of the previous statement, the statements which are consistent, they will rely upon those. And the contradictions, they will conveniently ignore. And that is the same thing which is also done by the learned. Contradictions regarding the entire incident, especially the incidents after, because conduct, my lord, both previous as well as subsequent are relevant. Lordship will also examine her previous conduct in the sense her journey to that house, subsequent conduct, her journey from that house. Both of these are relevant. Both of these, as by PW3 and as also accepted by the trial, shows her concept, my lord, her. At the end of the day, whether there are materials, of course, some materials are there, whether these materials are sufficient to prove the case beyond, that is something which the prosecution is getting. This is a case whether this is beyond all reasonable. In my respectful, sir, reasonable doubt remains. I'll place the judgment. Since your lordship is hearing the matter, I'll also place the judgment.
And in the cross part also, he has clearly asked on the part of the consent, he is clearly denied. It is not a fact that I have a good relation with Nitul from before, and it is not a fact that due to any such reason, I had voluntarily gone with him to the under constructed house and had sexual relation with him with my own consent. And it is not a fact that due to any such reason, I had not raised scream or hue and cry. It's clearly there, dear lordship. And her friend also stated that, lordship, she was taken inside the room by one of her friend, lordship, Deepak, lordship, co-accused, co-accused, no? No, Debojit, sorry, lordship, Debojit. And he shut the door, lordship. It is dear lordship. My learned, remains.
Your Lordship, I am appearing as amicus. All the facts are already placed by both the sides. Lordship, but here only thing is that whether they successfully proved the case that consent was there or not. So to prove that fact, Lordship, what I find, Lordship, subject to correction, that they're going there was no dispute that she voluntarily went there, that part is there in the evidence. Now, whether there was consent from the part of the victim or not, that has to be seen, Lordship. But here, Lordship, will find that cross part, Lordship, my learned friend has already placed that the victim categorically denied that part. And section 114, as my learned friend read, that consent, that presumption also is there. But from that, they also admitted that part that regarding sexual intercourse. And injury is there, that reasoning is given by the learned trial court that your lordship will find at page, and facing that part, lordship. Page, paragraph 34. Relevant portions are also 33, 34. And I do not find any, lordship, that other ground to say that the reasoning given by the trial court is perverse.
Doesn't have to be perverse. Wrong is enough in an appeal.
If your lordship set aside that order, then there has to be that these reasons
This is
are
not a revision.
yes, not born out of
This is an
record.
appeal, continuation of the trial. Can come to a different view.
Yes, that absolutely. Your lordship can appreciate the evidence.
Then
That much.
I'm just speaking with Ganeshan, my lord, regarding the potential.
only thing is that since I was under the assumption that we're hearing the IA, I did not note down the points made by you. So after that, I started noting after prosecution started. As far as your points are concerned, you can just make a
I'll make a brief note
bullet
and
point
I'll-
or
I'll-
something like that and give it to me. Because nowadays we can spend the yes, but that is all takes a lot of time again.
I'll prepare a note, my lord.
Besides, I don't like watching myself.
I'll place the judgments and my lord along with the note.
Yes, CAV.